Wait, listen. So I will
Yes.
to item number 10, my lord.
Ah,
There is some subsequent development, my lord, so we have to file an additional affidavit.
all right, Mr.
M. Hussain on behalf of M. Mondal.
M.U. Mondal and counsel for the petitioner submits that there are certain subsequent developments in this case and therefore the petitioner be granted a week's time to file an additional affidavit. Prayer is allowed. Let the matter be listed again after the additional affidavit is brought on record.
My lord, there is an interim order, my lord, that may be continued.
You have taken the consent of other side.
Yes, my lord, I. informed.
In fact, it is with regard to compensation amount. On the last occasion, as per instructions, they have received.
List again in the next week. Interim order passed earlier to continue.
Apply.
My lord. This is a mention paper.
Of course, it is a mention. What do you want?
The petitioner will withdraw the case. Make a please settle the matter.
Yes,
It
yes.
is.
You can't give me, you have to give it to her.
Okay.
Yes.
Wait, please, your lordship.
Hmm.
Item number 18 is a fishery matter, my lord. Some difficulties were there, some wrong documents were annexed. I pray for liberty to withdraw and refile again. Unfortunately.
Mr. S. Banik, Learned Counsel for the interim order was.
No, it's a petition, motion. First motion.
Mr. S. Banik, Learned Counsel for the writ petitioner submits that there is some defect in constitution of the writ petition. Full stop. Therefore, the petitioners be granted the petitioner be granted liberty to withdraw this writ petition with liberty to file afresh. Since the prayer is not opposed by the respondent's counsel, same stands allowed. Writ petition stands disposed of on withdrawal with liberty as paid for. Yes.
In a second case, may I pray for listing of a motion matter? In respect of a cooperative society, now different tomorrow,
Friday.
Friday.
May I please, Lordship, we have filed one additional affidavit in item number 24. Lordship. Kindly call this.
Yes.
May I pray for listing of a admission matter in the next week, Monday?
After vacation.
No, yes.
My lord, we have filed to IA for dismissal of the case due to default of lawyer, my lord,
Next
So-
week. Next week.
next week.
May please, Your Lordship. Lord, I'd like to mention item number 44. An affidavit has been filed by the respondent yesterday. We'd like to file a reply to that, my lord. 10 days time will be granted.
You are for the petitioner.
I am for the petition.
Mr. B. Kaushik, Learned Counsel for the writ petitioner submits that counter affidavit on behalf of the respondent has been filed only yesterday.
Yesterday.
By serving copy upon him. And therefore, the petitioner be granted 2 weeks time to obtain instruction. And therefore, he be granted 2 weeks time to obtain instruction and file rejoinder. Prayer allowed. Let this matter be listed after the rejoinder is filed.
But there's a connected repetition which is listed today in item code number 12, 5309/2023. That is the first repetition itself.
On the
Okay.
request of Mr. Kaushik, let this matter be listed again along with WPC number
5309/2023.
5309 of 2023, which is stated to be connected with this matter. Yes.
May I please, Your Lordship, I beg to mention item number 31, Lordship. Lordship, we need to file an affidavit in opposition. Lordship, we need some more time, Lordship.
You are for whom?
Industries and Commerce Department.
You have informed the other side.
Yes, Lordship.
Mr.
N. Kalita.
N. Kalita, Learned Counsel appearing for the Industries and Commerce Department, seeks 2 weeks further time in this case for filing counter affidavit. Since the prayer is made with the consent of the other side, same stands allowed. Let this matter be listed again after the puja vacation. In the meantime, counter affidavit by the respondents be brought on record. That's all.
Obliged.
May please, Your Lordship, on 29 September 2023, this honorable were directed to list this matter, Lordship, after vacation, Lordship. There should some urgency, Lordship, if possible, before puja, Lordship.
What is the urgency?
Lordship, the respondent have constructed this building over my boundary wall, Lordship, by extending this cantilever, Lordship, even after issuance of notices by the Golpara Municipal Board, Lordship.
So what is the urgency here?
He
He has already constructed.
No, construction is going on, Lordship.
If it is illegal, it will be demolished. What is the urgency here? If you succeed in the writ petition, which you are not likely to,
Yes.
then it will be demolished.
I beg to mention item number 35, Lordship. In
Item number 35.
35, Lordship.
Yes.
This is still a newly engaged, Lordship. That we have already
Who
submitted.
has been newly engaged?
We have already filed okalatama that is not taken the record lordship.
I have not understood. What is your prayer?
Lordship, in this case, lordship, we have filed okalatama lordship. কিন্তু the okalat not taken record lordship.
The earlier councils are not appearing.
Not lordship.
What is your name?
Mediation lordship.
Mr. B. Hussain, learned counsel submits that he, along with his senior, who is your senior?
Ayat Alagdar lordship.
Ayah Talukdar have been recently engaged in this case on behalf of the writ petitioners.
Edit petitioner.
Writ petitioners, but their names have not been shown in the cause list. Registry to verify and list this matter again after 2 weeks by reflecting the name of the counsel for the writ petitioners in the cause list. Yes.
Hi, Lord.
May I please, your lordship? My lord, I beg to mention item number 50, my lord. For the petitioner, my lord, I have taken consent from the other side, my lord. My lord,
Item number 50, what do you want?
Passover for other, my lord. I have taken consent, my lord.
On the prayer of learned counsel for the petitioner, this matter stands adjourned for a week.
Hello, lordship.
May I please, your lordship? I beg to mention one listing WPC 445323, your lordship.
For what? Listing for what?
Your lordship, this matter is pending,
No, there are many matters pending. Why do you want this to be
the
listed?
urgent matter, your lordship.
What is the urgency?
Lordship, it's a non-payment of retirement benefit.
Go to bench 3, civil bench 3. This is the wrong bench. Non-payment of retirement dues is civil bench 3. Your client is from which department?
Your lordship, he's an assistant officer, your lordship,
In which department?
in the company, your lordship, Assam Polyester Cooperative Society Limited.
So you have to go to the right bench, civil bench 3 matters. One mention this, yes.
May it please your lordship. Lordship, I beg to mention item number 6, lordship. Lordship, can the matter come after 2 weeks?
You are for whom?
For the petitioner, lordship.
Your name, please?
D. Roy.
On the prayer of Mr. D. Roy, learned counsel appearing for the writ petitioner, this matter stands adjourned for 2 weeks.
Obliged, lordship.
Daily list from withdrawal, item 1 and 2.
Your name, please?
G.
You want to withdraw?
With liberty, money.
Withdraw it?
Liberty, we have to sense the prior portions actually in both cases.
Who is appearing for the government? Any objection?
G. Gogoi was. But for
Mr. G. Pathak, learned kaha?
For forest department is
He wants to withdraw with liberty. Mr. G. Pathak, learned counsel appearing for the petitioners in both these writ petitions submits that there is some defect in constitution of the writ petition, more particularly in the prayer portion, as a result of which the writ petitions are required to be withdrawn with liberty to file afresh after rectifying the defect. Ms. G. Hazarika, learned SC, Revenue Department, Assam, and Ms. S. Borua, learned Government Advocate, Assam, are present. Revenue is a party here,
lordship. That's one number 5, lordship.
are present and do not have any objection if the prayer is allowed. In view of the above, both these writ petitions stand disposed of on withdrawal with liberty as paid for. Yes.
On motion, item 3.
Yes, who is appearing? Passed over. Next one.
4. Item 4.
And for the respondents, your lordship.
Just pass it over for the time being and then close it.
Item 5.
Meet with the lordship. Lordship, matter is pertaining to lordship mutation to dispute lordship. Lordship, lordship in petition, the disputed land is in petition possession since in the year 1995 lordship. Lordship, therefore in the year 2020 lordship, through a RT application, the petitioner got to know that his possession land has been illegally muted to the respondent number 7 and 8 lordship. Lordship, in this case, there is a remedy available lordship under subsection 2 of section 53A of the Assam Land and Revenue Regulation 1886. So kindly allow us to liberty may be given to us to approach before the Deputy Commissioner also.
All right. You want to withdraw this petition to avail statutory remedy?
Lordship, already the 3 years has been lapsed, Lordship. As per section.
No, no, what is your prayer? What is your prayer? You want to withdraw the writ petition
Yes, Lordship.
with liberty to?
Approach before a deputy commissioner, Lordship. As per subsection 2 of section 53A.
Subsection 2 of section 53A.
A of the Assam Land and Revenue Regulation 1886, Lordship.
Mr.
Jay Hatimoria.
J. Hatimuria, learned counsel for the writ petitioner submits that the petitioner is aggrieved by the mutation of the disputed land granted in favor of the private respondents. Full stop. However, Mr. Hatimuri, when this matter is called up today, Mr. Hatimuria submits that there is an efficacious alternative remedy in the form of an application to be filed under section 53 capital A
Yes, Lordship.
bracket 2 of the Assam Land and Revenue Regulation 1886 before the Deputy Commissioner of the district, and therefore the petitioner be granted leave to withdraw this writ petition with liberty to pursue the alternative remedy. Full stop. The prayer is not opposed by Ms. G. Hazarika, learned SC Revenue Department, Assam, and Ms. S. Borwa, learned Government Advocate, Assam, appearing for the official respondent. In view of the above, this writ petition stands disposed of on withdrawal with liberty as prayed for.
Obliged, Lordship.
Item 6. Item 7.
Yes.
Yeah, please, Lordship. My lord, page 20, my lord, the application was submitted for demarcation, Lordship. My lord, in 2022, my lord, that has not been disposed of yet, Lordship.
Lordship, we have received the instruction. Petitioner's application was rejected on 28/06/2022. Since the petitioner was not found eligible as he was not as a recorded as a pattara, Lordship. Lordship, may.
28/02/2022.
28/06/2022, Lordship.
His
His petition
application for
was
demarcation was rejected.
As he was not found eligible, as his name was not recorded as pattara, Lordship.
My lord,
No, no, rest
It
of the
was-
things you can't
it was
argue
not
here.
communicated, Lordship.
All right.
It was not
So-
communicated,
Lordship,
Lordship.
Lordship,
Just-
Copy is there with you? Do you have a copy of the order? Do you have a copy of the order
Yes,
dated
Lordship.
28/6/2022?
Page 11, Lordship.
Lordship, but it is in particular, Lordship. We have
So
not
what is the
transferred.
problem? You give me. So we'll close it. You avail appropriate remedy against the order.
My lord, before that, Lordship, for the timing, kindly see Lord, page 11, Lordship. Oh, this, my lord.
Mister, you have to prefer an appeal against this.
Lordship.
What is the point in unnecessarily using up the
My
court's
lord,
time? Ultimately, I'm going to close it by giving you liberty. Your grievances with your application is not acted upon. He has acted upon and rejected it
It
for
may be
good, bad
disposed-
reason. That is not under challenge in this proceeding.
Lordship,
Then you have to avail your remedy now.
my lord.
You know, I'll ask her to give you a copy of the order. Give him a copy. Take down. Next, Mr. M.H. Ahmed, learned counsel for the writ petitioners. Also heard Ms. G. Hazarika, learned standing counsel, Revenue Department, Assam, appearing for the respondent number,
One, Lordship.
respondent number 1. Ms. S. Borwa, learned G. Assam, is present on behalf of respondent numbers 2 and 3. Full stop. The grievance of the petitioner is to the effect that his application for demarcation of land submitted before the circle officer Dangtol Revenue Circle, Vidyapur, Naldoba in the district of Bongaigaon. Way back on, when was it submitted?
It was submitted, Lordship. My lord, 16/7/2022.
16/7/2022,
Lordship, page 20.
and it has been dismissed on 28 June 2022.
My lord, I was not aware of, Lordship. We are not hard.
I have
How
only
can
one
he
copy,
dispose
Lordship.
of a application in June, which was filed in July?
My lord, page 20, kindly please see, Lordship. I'm sorry, Lordship, it is 16/6/2022.
16/6.
2022.
And it was disposed of
So
20.
16/6/2022.
2022. Full stop. As per order of this court, Ms. Hazarika has obtained instruction and produced a copy of the order dated 28/6/2022, passed by the respondent number 3, rejecting the application of the petitioner on the ground that, on the twin grounds that he is not a recorded pattadar, and the applicant was also not present on the date of hearing fixed in the matter. Mr. Ahmed has, however, strongly refuted the said contentions and submits that the order dated 28/6/2022 has not even been communicated to him till today.
Lord.
Full stop. The petitioner may have a genuine grievance on the count as urged by the petitioner's counsel, but the said issue cannot be entertained in the present petition, since the order dated 28/6/2022 is not under challenge. Moreover, the petitioner has a alternative statutory remedy against the order dated 28/6/2022. In view of the above, by granting liberty to the petitioner to pursue appropriate legal remedy that may be available to him in the facts and circumstances of the case, his writ petition stands closed. Ms. Hazarika to furnish a copy of the impugned order dated 28/6/2022 to Mr. Ahmed during the course of the day. We give him a
Alright.
copy. Yes.
Deputy Obliged.
You had a copy of the order dated so and so, we also retain in the record of this case.
May it please, your Lordship.
Yes.
Lordship, yesterday the petitioner number 1 appeared before the medical board, Lordship. This is the report, Lordship.
What is the report says?
Lordship, termination can be done, Lordship. She is 21 weeks, 3 days.
My lord.
So then you proceed in the matter. Acha, you take down, heard Mr. Ayer, yes,
My lord, my
we'll
lord.
close the matter then.
My lord, some other reliefs are there.
What other relief?
They regarding the action by the army
Ah.
to the person who has committed the crime,
That has to follow the course of law.
Course of law, Army Act is there, but they are sitting silent and the police case is also pending, My lord, may issue notice in the meantime, the private respondents are also there and this can be, done,
Heard Mr.
My-
Yag, we are learning counsel for the writ petitioners, also heard Mr. D. Upamanu, learned SC Health and Family Welfare Department, Assam, appearing for the petitioner number 1. Miss R. Devi, learned CGC is present.
1345. Yeah, received the parawise comment.
Petitioner number 2, the petitioner number 2, is R. Devi, learned CGC, appearing for petition, respondent numbers 1, 2, 1, 3, 4, and 5. Are you also appearing?
Yes, 267.
Mr. S. Barua, learned G. Assam is present on behalf of respondent numbers 6 and 7. The instant writ petition has been filed on multiple grounds, but the most pressing ground taken in the petition was for medical termination of the pregnancy of the writ petitioner number 1. who- Medical termination of the life fetus of petitioner number 1, who is a rape victim. Full stop. Taking note of the submission of the learned counsel for the parties This court had passed order dated 29/9/2023, directing the principal of the Guwahati Medical College and Hospital at Guwahati to constitute a medical board and examine the petitioner. Constitute a medical board for examining the petitioner and thereafter to submit a report. Accordingly, the petitioner was examined by a 3-member medical board headed by Dr. Divyajyoti Gharpalia, Associate Professor, ONG. Under the chairmanship of Dr. BP Das, Professor and HOD, ONG, GMCA Chairman. Whereafter, a report dated 3/10/2023 has been submitted. Perusal of the report goes to show that the petitioner number 1 has completed 21 weeks, 3 days of pregnancy as per the ultrasound report, and it was possible to terminate her pregnancy. Terminate her pregnancy medically as early as possible in the Guwahati Medical College Hospital. Mr. Bhuya submits that his clients are willing to go ahead with the process of termination of medical termination of pregnancy of the petitioner number 1. However, since there are other issues raised in the writ petition, this matter would have to be the writ petition would have to be admitted. No, you're right. Issues. Therefore, the issues raised in the writ petition would call for further examination. As such, issue notice of motion returnable in 4 weeks. Since the respondents are represented, no formal notice is required to be sent in this case. Extra copies of the writ petition be furnished to the learned department counsel so as to enable them to obtain instruction and file affidavit. In the meantime, the GMC authorities may proceed with the medical termination of pregnancy of the petitioner at the earliest.
Petition number 1.
Petitioner number 1 at the earliest. Both the petitioners to render full cooperation in the matter.
Obliged.
A copy of the report dated 3/10/2023 be retained in the record.
Lordship, a copy of this order.
A copy of this order be furnished to Mr. D. Upamanyu during the course of the day.
Highly obliged.
Highly obliged.
No.
May it please yours.
Yes.
My lord, sir, I refer to order dated 13/9/2023.
Lordship, on last occasion, we had received a communication that they will be allowed jute cultivation. But Lordship, after that, we have not received a written communication yet. So Lordship may grant us 1 week time, but our decision has been taken, Lordship.
My lord, in the meantime, my lord, 30% of the suit is dried up. And
We'll take it up day after tomorrow. And
Yes,
if the instruction is not made available in writing, we are directing the officers to be present personally at 2 p.m.
obliged.
I had Mr. M. S. Sheikh, Learned Counsel for the writ petitioner, on the request of Mr.
I bought her.
I. Bhattakur, Learned Standing Counsel, Forest Department, Assam. This matter is directed to be posted for motion again on 6/10/2023 as a fixed item, so as to enable him to obtain written instruction in the matter. Full stop. Ms. K. Fukan, Learned CGC, has appeared for respondent number 1. Ms. G. Hazarika, Learned SC Revenue Department, for respondent number 3, are also present. Where is your senior?
Lordship, he's on legs at court 1.
Friday, we want concrete answers.
Yes,
Otherwise, they are coming to the court and then we'll
Yes.
deal with it. He has given an assurance to the court. It has to be now complied.
Yes, sir.
Yes.
Obliged, Lordship.
Much.
Yes.
My lord, our land has been acquired, my lord, and compensation has been awarded. And proposal has been sent for, my lord, payment, page 36, my lord. Page 35 and 36.
So what is the problem here?
My lord, one third party filed a complaint before the circle officer that they have filed a title suit, so entire amount has been stopped.
We can't do anything about it. Which is the title suit?
They have not numbered, my lord.
Who are the third party?
Page, my lord, 37, my lord, the application I have annexed, my lord.
No, they are respondents in this case.
Lordship, I have made.
So we have to issue notice then at this stage. Had Mr. A. Ali, learned counsel appearing for the writ petitioner, peruse the amendments made in the writ petition. It appears that land belonging to the petitioners had been acquired for the purpose of
Polasbury Walkisi Bridge, my lord.
Polasbury Concrete,
Polasbury Walkisi Bridge, my lord.
Polasbury Walkuchi Bridge. The amount of compensation payable to the sole petitioner or
No, my lord,
to the petitioner
petitioners, my lord.
has been assessed at rupees 92,69,567.12 against the land measuring 1 bigha 15 lasses and a further amount of rupees 3,22,419.72 against the land measuring 4 lasses. However, the amount has not been released in favor of the petitioners on the ground that there is a title suit filed by the respondent number 4, which is pending before the civil court. Mr. Ali submits that there is no such title suit pending before the court, notwithstanding the same. And Mr. Ali submits that to the knowledge of the petitioners, there is no such title suit pending before the civil court. Notwithstanding the same, the genuine dues of the petitioners, as stated above, have been held up by the authorities. Ms. G. Hazanika, SC Revenue Department, Assam, and Mr. S. Borwa, G. Assam have paid for some time to obtain instruction in the matter. NOM 6 weeks since Ms. Hazanika has accepted notice for respondent number 1 and Mr. Borwa for respondent numbers 2 and 3. Service of notice is deemed to be complete on respondent numbers 1 to 3. Extra copy of the writ petition be furnished to the Learned Department Council. Petitioner to take steps for service of notice upon respondent number 4 by registered post with AD. List this case again after 6 weeks as a fixed item. You want the payment to be made in the meantime? You are unable to even utter that, huh? Because you know that kind of a relief cannot be paid now. That is the dilemma, you see. We have all faced it at some stage. Yes.
Please, Lord. My lord, here two writ petitions, my lord, have come, my lord. In fact, both the writ petitions, my lord, have raised the same question. And if your lordship takes up the WPC 5400, it will be convenient for your lordship, my lord. This is a detailed one.
Yes, WPC 5400.
Petitioners are being represented by my lord friend, my lord, Mr. Gotakot. Now, what has happened, my lord?
Yes.
The registrar had passed an order 1923 allowing the private respondents, my lord, to participate in the election. Now, this order, my lord, is challenged on the ground that it is illegal and without jurisdiction, my lord. In the teeth, my lord, of embargo, there is a, my lord, express provision, my lord.
No, there is a AGM of the society is fixed.
In fact, what has happened? Yes.
When is it fixed?
My lord, it was fixed on 17/9/23, and that has, your lordship is allowed that.
So it has been held.
Yes.
It has been held, but approval was not granted in view of the interim order passed by this honorable court.
approval, my lord, is awaited, my lord, pending disposal of this writ petition. Now, the question is, my lord, whether the order 1923, my lord, is permissible in law or not. That is the question, my lord. Because otherwise there is an embargo under section 40, subsection 4A, which says, my lord, that the defaulting members, my lord, they are debarred, my lord, from participating in the election. So there is an express provision of law. And my learned friend, my lord, has argued that in the teeth of these provisions, my lord, that this order is without jurisdiction. So I have to show your lordships, my lord, that it is permissible.
Lordship, before that, Lordship, if I may be allowed to place my case.
So therefore, it has to be disposed of.
Lordship.
We'll have it on Tuesday. then.
Lords.
In the meantime, parties are all represented.
Yes, yes, correct.
Notice has not been issued, but he has.
But he has appeared, all
Well,
parties are
I'll issue
represented.
notice today and fix it on. Heard learned counsel for the petitioners appearing in these cases. Also heard Mr. S.K. Talukdar, learned SC Cooperation Department, Assam, who submits that this matter calls for expeditious disposal since the approval of the AGM held on 17/9/2023 is being held up due to the interim order operating in this case. The learned counsel for the contesting parties have also agreed to expeditious disposal of this writ petition. As such, issue notice of motion returnable on 10th of October 2023. Since Mr. S.K. Talukdar, learned counsel, has appeared for the official respondents in both the writ petitions, and Mr. M.K. Hussain has entered appearance on behalf of the private respondents in both the writ petitions. Anybody is left who is not represented?
No, no, everybody is represented.
Everybody is.
Service of notice is deemed to be complete in this case. With the consent of learned counsel for all the parties, this matter is directed to be listed again on 10/10/2023. These matters are directed to be listed again on 10/10/2023 for admission hearing as fixed item. An
Right.
attempt would be made to dispose of the writ petitions on the next date fixed, parties to come prepared accordingly.
Obviously.
Interim shall continue till then.
Interim order passed earlier to continue till then.
Item 14.
Last occasion, your lordship order dated 25/9/2023, my lord, second paragraph. After going through the writ petition, this court had made a query as to whether the order dated so and so was reviewed after order dated 6/7/2002 was passed by the additional deputy commissioner Kasar, or is there any proposal to review the said order in view of the correndum proposed by the district administration?
Yes, what is the instruction?
Lordship, in Annex 10, Lordship, DC has directed, page 46. Necessary corrigendum clarifying the portion of proposed road falls in NHA 306 and 337 may be notified specifically. So, Lordship, as per the, we have already notified the public notice, Lordship, regarding.
Yeah, we should notification, that's all.
Yes,
Writ
that's all,
petition is
Lordship.
infructuous.
This is the.
You have a look at the notification. First, look at it. Then say yes or no.
Public notice kete koriche. 26/9.
Regarding.
This is a 26/9, my lord.
Yes.
Yes, today we are going to publish, Lordship. I have made the statement before, your Lordship. Today we are going to publish in the newspaper, local newspaper.
By
And this
giving
is
the
a job
correndum.
public notice.
Yes, so what remains in your writ petition then?
Yes.
Yes.
My lord, and last page 46, my lord.
Hmm.
The deputy commissioner order, my lord. Page 46, last paragraph, my lord. Considering the above fact, I am the opinion necessary correndum clarifying the portion proposed route so and so and may be notified specifically. I am also of the opinion that alignment proposed 4-laning Silchar within gate route is a technical matter. Hence, NACDL is requested to take up the matter. Correndum clarify the specifically in NH which is involved proposed route by issuing a notification. Further,
Yes.
NSDL also be requested to look into matter alignment proposed route is to be technical issue.
Technical.
Regarding the
They are issuing, publishing the notification.
Yes.
That is the relief you wanted.
Ma'am.
Yes, heard Mr. N. Bora Learned Counsel appearing for the writ petitioner. Also heard Miss R. Bora Learned Standing Counsel NHI
NHIDC,
appearing for the respondent numbers
2 and 3.
2 and 3. Miss, who else is appearing? Please give a copy of that.
Yes.
Who is for respondent number 1? Miss R. Devi, Learned CBC is present on behalf of the respondent number 1, comma. Miss MD Bora, Learned FC Transport Department, Assam for respondent number 4, and Mr. S. Borua, Learned Government Advocate, Assam for respondent numbers 5 and 6. This writ petition was filed primarily with the prayer to issue a direction upon the respondent numbers 2 and 3 to implement the order dated 6/7/2023 issued by the Additional Deputy Commissioner Kachar, Silchar, to publish a notification clarifying that the portion of the proposed road falls in NH 306 and NH 37. Full stop. According to the petitioner, notwithstanding the direction to publish, notwithstanding the corrigendum issued by the Office of the Deputy Commissioner, no action has been taken in the matter till today by the respondent numbers 2 and 3. Full stop. By the order dated 25/9/2023, the Learned Standing Council was asked to obtain instruction in the matter. Accordingly, today, when the writ petition is called up, Miss Bora, Miss R. Bora has produced a copy of the public notice, which is proposed to be published tomorrow. That is, give this so and so date tomorrow in the local newspaper, notify that what is the notification?
This is a public notice.
Public notice next week.
Next week.
Acha. Produced a copy of the draft of the public notice, which is proposed to be published in the newspaper tomorrow, that is so and so date. And submits that the instructions issued by the order dated 6/7/2023 is being complied with by the authorities. Full stop. I have perused the draft of the public notice, which was forwarded to the Additional Deputy Commissioner Kachar by forwarding letter dated 26/9/2023. After going through the same, this court is of the opinion that no live issue survives. This court is of the opinion that in view of the above developments, no live issue survives in this writ petition for adjudication by the court. Mr. N. Bora Learned Counsel for the writ petitioner has also fairly admitted to the said position. In view of the above, by retaining a copy of the communication dated 26/9/2023, along with the annexure in the record of this case, this writ petition stands closed. Yes.
Obliged.
May I please you, Lord? I am appearing on behalf of Mr. S. Hawk, and my senior is unable to come to the court because his one paternal uncle has died today. And I am humbly submission that the matter may adjourn for the day and listed for tomorrow or day after tomorrow.
You have received instruction?
Our lordship, instructions are awaited in this matter.
All right. Mr. Bhattakur.
Yes.
I Bhattakur,
Yes.
Learned SC, Forest Department, Assam submits that instructions as called for are still awaited. The petitioner's counsel has also prayed for posting this matter for motion again day after tomorrow, that is 6/10/2023. In view of the above, the registry to list this case for motion again on 6/10/2023.
Marshal.
16 and 17.
Yes,
The matter regarding appointment of a secretary of a cooperative society. And the petitioner before your lordship is the president of the board of directors of Paschim Mandya Shobha Samiti Limited. In this case, the board resolved to appoint the private resolution number 6 as secretary, that is page 16. For 24/7/2023. Then the Eastern Rest of Cooperative Societies by order dated 28/7/2023, that is page 19. The resolution was refused to approve on the ground that the resolution number 6 is overaged and underqualified. Thereafter, the board taken a resolution not to act upon that resolution, that is page 24, 10/8/2023. Then the ARCS illegally issued that order, that page 30, appointing the resolution number 6, page 30, in pursuance to the resolution number so and so, that is 24/7/2022 of the board of directors meeting so and so. Serial open person is the private resolution number 6, has been appointed as secretary. What is the power of the ARCS to appoint the secretary? And we are not to act upon the resolution.
Yes, Lordship may kindly have a look. Section 38 for a moment. The power of the board.
section 38.
38, my lord. Powers and function of the board. The Lordship may directly go to the 2, serial number 2, my lord. Power of the board to nominate. My lord, got it?
Yes,
To nominate, elect or appoint and remove the chief executive provided he is not a government appointee. So it is the board. Board has to appoint the secretary.
Then
Now, here for response number 6, since there is an appeal filed by the petitioners pending before the register, and we have also filed an appeal against the some order passed by the RCS. So let the appeal be disposed of by the Register of Cooperative Society. That's what section.
no, but what will you decide? You argue, you tell us, show us that prima facie, without the board resolution, the register has the
There
power.
is a
to
board
appoint.
resolution. There is a board resolution.
Where is it?
Yes, Lordship kindly see. Okay.
That has been withdrawn.
Yes. Now, my lord, earlier writ petition, my lord, WBC number 5039, Lordship analogous matter, my lord. In that case, we have filed affidavit, my lord. There is a
No,
resolution.
board resolution was initially of 24/7/2023.
Yes,
Now, that resolution, according to him, it has been withdrawn.
Subsequently, there is a resolution. There is a resolution. Lordship kindly see, take up the my lord, 5039. In that case, we have filed affidavit.
Affidavit by respondent number
6, my lord.
Which page?
My lord, affidavit in opposition, my lord, Lordship will find page 45. Page 45, my lord.
Yes. Yes.
Yes. Now, my lord, today's meeting, Lordship will find resolution number. Today's meeting has discussed about the letter number so and so, dated so and so, issued by the RCS Borpata in context of resolution dated 10/8/2023, adopted by the BOD as per the said letter, because of poor knowledge in English. Resolution dated 24/7/2025 on Lokman Hussain was selected for the post of secretary by the board.
But as per resolution number 2 dated 10/8/2023 and resolution dated 12/8/2023, two resolutions were adopted against the resolution dated 24/7/2023. Today's meeting has discussed the same and cancelled the resolution dated 10/8/2023 and 12/8/2023 and uphold the resolution dated 24/7/2023 and uphold the Lokman Hussain as secretary of the said society. That was the resolution. And original resolution was dated 24/7/2023.
And where is 10/8 and 12/8?
10/8, my lord. 10/8, my lord, lordship will find in the, my lord, writ petition. WPC, my lord, 5039. 28. Page 28, my lord. Page 28.
Yes. And the 12/8?
Page 28, my lord.
Who has filed appeal according to, who has filed appeal?
My lord, the present petitioner, my lord, in WPC number, my lord.
The president and some of the board of directors will not file their appeal. That is, my lord, in my petition, my lord.
Who is the petitioner in WPC number 5039?
On Minhasuddin.
Who is he?
Minhasuddin, he is the shareholder, your lordship. And as per last order, your lordship, I was asked to file additional affidavit. Whether the petitioner is shareholder or not. I have filed the additional affidavit.
No, we are not going to go in. You think the writ court will find out whether petitioner is shareholder or not? We are asking who is the one who has filed an appeal before who, which authority?
Yes, my lord, that is, my lord, present, my lord, WBC number 5688. Page, my lord.
32, my lord.
32.
So the president of the
Yes,
board
and
has filed an
board of
appeal.
directors.
Appeal against which order?
Against the Milot ARCS order, Milot. Yes, Milot 37, Lordship. Order dated 14/8/2023. That is Milot page Milot 19.
So your client has already filed an appeal.
Yes, yes, Milot.
Before the ARCS.
ARCS, Milot.
Then let the appeal be decided.
Then till that Milot, that order may be Milot suspended. Because Milot, the ARCS, Milot, somebody Lordship, Milot, the ARCS, no power Milot at all.
No, but your board has appointed him. There is a resolution.
That is the Milot, some I have seen Milot that in the, yes, Milot.
You are in item 17, is it? You are in item,
the item Milot 16.
You are in item 16.
Yes.
So there you have challenged the order dated 28 July 2023.
Yes.
And what is the challenge in the other writ petitions? What is the challenge in this writ petition?
Order passed by the ERCS, your lordship. Order dated 14/8/2023.
14/8?
Same order. Milot.
Same order.
Same
order.
Same order they have challenged, madam. They have challenged the same order. Lordship may kindly have a look, page 30 in the WC number 5688, the ARCS order, my lord. In the ARCS order, there is nothing written about the second resolution taken by the board. As per the resolution, first resolution, board 24/7, he has mentioned only that date. So lordship, the appeal may be this may be.
Lordship, in this case, your lordship, in 5039, your lordship, I have filed an affidavit in reply, your lordship, regarding the regulation adopted on 28/8/2023, your lordship. Lordship, kindly have a look at.
So you are challenging the order dated 14th of August.
Yes.
Where is that order?
Page 30, lordship, in repetition number 5688.
Let the RCS
My lord.
take a decision.
Register, my lord.
Register of Cooperative
Register,
Society.
my lord.
All right, you take down. Heard Mr. D.A. Kayum, learned counsel for the writ petitioner in WPC number 5688 of 2022. Also heard Mr. M. Khan, learned counsel appearing for the petitioner in WPC number 5039 of 2023. About to 22? No, Mutation 23. Stop. Miss M.D. Bora, learned standing counsel, Cooperation Department, Assam, has appeared for respond numbers 1 to 5 in both these writ petitions, whereas Mr. M.U. Mondal, learned counsel, has appeared for the private respondent number 6 in both these petitions. Full stop. Next paragraph. In both these writ petitions, the order dated 14/8/2023 passed by the Assistant Register of Cooperative Societies, Barpeta, approving the appointment of the respondent number 6 as the secretary of the Paschim Mandia GPSS Limited, based on resolution number 2 dated 24/7/2023, or adopted by the Board of Directors, has been put under challenge, inter alia contending that there is no valid resolution of the board backing the aforesaid order of the ARCS, Barpeta. Full stop. After going through the materials available on record, I find that although by the resolution dated 10/8/2023 and 12/8/2023, the Board of Directors had taken a decision not to implement the resolution number 2 adopted in its meeting dated 24/7/2023. Subsequently, by the resolution adopted in the meeting of the Board of Directors held on 28/8/2023, the resolutions adopted in the meeting held on 10/8/2023 and 12/8/2023 had been cancelled, thereby affirming the resolution number 2 dated 24/7/2023, whereby it was decided that the respondent number 6 should be appointed as secretary of the society. First of all, after going through the materials and record, it prima facie appears that there is a resolution of the Board of Directors nominating the respondent number 6 to be appointed as the secretary of the board. However, the secretary of the board, it appears that the order dated 14/8/2023 has been assailed by the president of the board by filing WPC number 5688/2023, whereas the same order has been assailed by a shareholder of the GPSS Limited by filing WPC number 5039/2023. Full stop. It has also been brought to the notice of this court that the impugned order dated 14/8/2023 is appealable under section 111 of the Cooperative Societies Act 2007, and the president of the board has already preferred an appeal before the Register of Cooperative Societies, which is pending disposal. Full stop. If that be so, these writ petitions need not be entertained at this stage until the appeal preferred by the president of the board is heard and decided on merit. The learned counsel for all the parties have also, if that be so, this court is of the opinion that the appeal pending before the Register of Cooperative Societies ought to be decided on merit before the parties can be permitted to agitate their grievance by filing a writ petition. The learned counsel for all the sides have also agreed to the said recourse. In view of the above, these writ petitions are disposed of with the consent of learned counsel for all these sides by providing that the appeal preferred by the writ petitioner in WPC number 5688 of 2023 be heard and decided on merit after giving an opportunity of being heard to all the interested parties. The aforesaid exercise be carried out as expeditiously as possible, preferably within 4 weeks from the date of receipt of a certified copy of this order. With the above observation, these writ petitions stand disposed.
Deeply obliged, my lord. Lordship, I am appearing for 1 to 4. 5 is private respondent. I am not appearing.
So 1 to 4 for you.
My lord, obliged, my lord.
Caveat stands discharged.
My lord. Obliged, lord.
Item 90.
May I please? No, there is another matter, item 55 in the supplementary list. Both the matters are identical. Your lordship may take both the matters. My lord, your lordship will find here Sri Hari Mandir Nalbadi, a religious denomination, filed the instant writ petition against the two orders dated 20.
This matter will take some time.
Yes, it will take some time.
Then we'll call it a little later.
Yes.
Let the other motion matters be over.
Lordship.
We'll call it at around 12.
Lordship. Always.
Yes.
My lord, 20 and 22 may pass over today. There are some mistakes in the paginations. I will correct it.
Mr. H. Morial, I counsel for the petitioner submit that there is some mistake in the pagination of this writ petition and therefore this matter be passed over for the day so as to enable him to rectify the defect. Prayer allowed. Let this matter be listed again after rectification of the pagination. 20 and
22.
22 also same order. Yes.
Item 21.
Yes.
Your Honor, please kindly pass over the matter.
What is it about?
Your Honor.
Why you want it to be passed over?
My senior is in another court.
All right, but second call, if it doesn't come, then we'll have it after some time.
May it please your lordship. Lordship, the matter relates to grave and unjustified delay on the part of the respondents in implementing the order passed by learned RERA. Lordship, the order was passed on 29th of September 2022, whereby Deputy Commissioner was instructed to recover a sum of 71,29,342 rupees as arrear of land revenue. Lordship, 1 year has elapsed and yet no steps have been taken by Deputy Commissioner. Lordship.
Which is the order of RERA?
Lordship may find the order on page 43. Third paragraph. This authority, therefore, in exercise of the power under section 41 of the RERA Real Estate Regulatory and Development Act 2016, read with Rule 25 of Assam Real Estate Regulatory and Development Rules 2017, directs the Deputy Commissioner Kamrup Metro to recover an amount of rupees 45 lakh principal amount plus 26 lakhs 29,342 interest amount so and so under only as arrear of land revenue and pay the same to Shri Pradeep Kumar Gupta with information to this authority. Lordship, many reminder letters have been sent by RERA as well as the petitioner, yet no steps have been.
I will just issue notice, but is the High Court the executing
Lordship,
forum?
we had, since the direction was given to the builders to pay 45 lakh plus interest.
they did not execute the order. Then a executive petition was filed by the petitioner. Thereafter, this order was passed whereby the deputy commissioner was instructed to
That's
recover.
all right, but High Court cannot be the executing court for orders passed by RERA authority.
Lordship, this writ petition is filed to direct the deputy commissioner to expedite.
Oh, I have understood that.
Yes, Lordship.
I can make it out. But you must have some mechanism under the RERA Act for implementation of this.
No, Lordship, there is no provision in RERA Act for the same.
Heard Miss
P.
P. Gupta, learned counsel appearing for the writ petitioner, peruse the averments made in the writ petition. The petitioner is primarily aggrieved due to non-implementation of the order dated 29/9/2022 passed by the Real Estate Regulatory Authority, Assam. Mr. N. Goswami, learned government advocate, Assam, praised for some time to obtain instruction in the matter. NOM 6 weeks since Miss G. Hazarika, learned SC Revenue.
N. Borderline.
Sorry, Miss N. Bordelais, learned SC Revenue has appeared and accepted notice for respondent number 1, and Mr. N. Goswami, learned G. Assam for respondent numbers 2.
For 2, 3 and 4. 2, 3 and
No formal notice is required to be sent in this case. Extra copy of the writ can be furnished to the learned department counsel so as to enable them to obtain instruction. The question of maintainability of the writ petition is kept open and then be gone into at the stage of admission hearing.
Lordship, item number 25 is similar matter.
Same order,
Yes, Lordship.
order dated same.
Order dated different but same party.
What is the date of the order? Item 25, what is the date of the order?
One, Lordship, thought 21/2023.
21/2023 and tag along with this matter. Yes. Same order.
Achha.
To appeal for the petitioner. Now, this matter is pertaining to partial rejection of my claim under the budgetary support scheme. Malad, this period entailed in this matter is April to June 18. Prior to this, there were 3 quarters. This scheme started from July of 2017. So prior to this, there were 3 quarters. Similar orders were passed in those quarters also. We had filed a writ petition before this honorable court against those orders also. My lord, they can see my additional affidavit, annexure 4, page number 145. My lord, the same order may be passed in this matter also, and both the matters can be tagged is what my prayer is.
Additional affidavit, I have not seen.
Sorry.
Additional affidavit, copy was not served on that.
Additional affidavit copy was not served on this.
Where is the earlier order of the court? Which page?
145, my lords. Same case, sir. Same high case itself for the prior period.
Okay, yes, sir.
He's saying what is.
मेरे फाइल में नहीं है, मैं झूठ थोड़ी बोल रहा हूँ।
One 145, my lords.
Yes, what do you say, Mr.
Lordship, for the additional liquid, this have been served on me. Lordship, may take up on Monday. I'll obtain instruction from the department.
My lords, I am from outstation. My lords, may kindly issue notice and tag both the matters together. Admission is anyways pending in the earlier matter also.
So other matters are pending. What instruction? You're Mr.
Mihir Mehta.
Or Mr. Mihir Mehta, learned counsel appearing for the writ petitioner. Also heard Mr. S.C. Kyle, learned standing counsel GST authorities appearing for the official respondents aggrieved by the order dated 13/8/2019. Is it?
No, my lords. There
Is
is
the order you're challenging?
2 orders, my lords. 13/8/2019 is the original order. And after that, we went into an appeal also. That also was dismissed as non-maintainable. That is 27/10/2021.
Aggrieved by the order, the original order dated 13/8/2019, as well as the order dated 27/8/2021 passed by the appellate authority. The petitioner has approached this court by filing the instant writ petition, interview contending that although the petitioner was entitled to budgetary support in terms of the notification dated 5/10/2017, the same was denied to it.
Partially denied.
The same was partially denied to it on grounds which are not tenable in the eye of law. Mr. Mehta has further invited the attention of this court to the order dated 4/1/2021 passed by the learned single judge in WPC number 5761/2020 to submit that similar writ petition raising the same issue is pending disposal before this court, wherein an interim order is operating. As such, a similar order be passed in the present case as well. Mr. Kyle has prayed for some time to obtain instruction in file affidavit. In view of the above, NOM 6 weeks, since Mr. Kyle has appeared and accepted notice for all the respondents, no formal notice is required to send in this case. Extra copies of the writ petition be furnished to the learned departmental counsel so as to enable him to obtain instruction in the matter. Heard on the prayer of interim relief. What is the interim order?
Nothing is there.
Nothing,
There's
no interim order.
No interim order.
Only, no, it's a refund matter, my lord. There is no interim requirement.
Then there is no interim relief. Earlier part is interim relief is not required.
My lord,
List
only one request, my lord. If both the matters can be tagged together because the petitioner is the same, only the period is different. So earlier is for the period July
list
17 to
along
March.
with WPC number 5761/2020. So there he submits that a similar matter filed by the same writ petitioner pertaining to a
previous
different
quarters.
period is pending disposal before this court. And therefore, this matter be also admitted and tagged together.
But see, preliminary objection regarding maintainability was kept upon in that case also. That may
The
be.
question of maintainability of the writ petition is kept open and shall be gone.
My lord, the reply is not filed in the earlier matter also. So my lord may kindly ask them to expedite that as well because.
We'll do lots of within.
How can we pass an order?
No,
in
no,
the
no,
earlier-
I am not an order, I'm only bringing to the attention, order was of 2020. No reply has been filed in that also. Much obliged.
Notice has been issued today. They will file it.
No, no, my earlier matter. Anyway, the earlier matter also,
You know what you are asking for is not bona fide.
obliged, my lord.
Don't ask for it then.
Made to the lordship. Well, petitioner before your level lordship, well, had submitted well an application well before the.
Sorry, what is
Commissioner well.
what is it?
Well, petitioner before your lordship, well, had submitted an application before the Commissioner of Guwahati Municipal Corporation, well, for renaming of an existing road, well, from South Saran Masjid Road to Alhaz Rahman Ali Road, well. The petitioner had submitted on 25/11/2021, well. Now, well, they had recently, well, they had rejected that prayer, well, case 17, well. Well, although, well, it's in a paper publication as well as, well, public hearing, well. They did not cause neither hearing nor public notice, well.
Why should they rename the road? Because you want it? Who are you?
Well, we're the society, well.
So
we are associated, well. It's
you
there is
can't
prov-
ask for all these
well,
things.
they usually, well, there is provision probably, well, in the municipal corporation, well. Because I have placed hard kindly see, well.
Lord Mr. Ashok Lane, counsel for the petitioner, peruse the amendments made in the writ petition. NOM 8 weeks. Since Ms.
J. Rajkumari on behalf of Espora.
J. Rajkumari, learned counsel has appeared for respond number
123.
123. That is all the respondents.
All the rest.
123, no formal notice required. Extra copies be furnished. Yes. 8 weeks.
Item 27.
Yes.
My lord,
Only two options, either notice returnable in 8 weeks and dismissal after 8 weeks or dismissal today. Which do you want?
well, at least.
Disposal
notice may be-
today.
At least notice may be set.
That's what I've done.
My lord, my lord.
May I please, Your Lordship, let's- by this petitioner prayed for demarcation of a plot of land, my lord. My lord, that has been not done more than 1 year and 10 months. My lord.
All right, we'll ask him 10 days if you to find out what has happened.
My lord,
Just tell
similar,
us. Heard Mr. A.K. Hussain, Lorry, counsel for the petitioner. The petitioner is aggrieved by non-consideration, aggrieved due to non-consideration of his application for demarcation of the land. Mr.
R.K. Musari.
R.K. Musari,
2, 3, and 5,
and
6.
counsel appearing for respond numbers
2, 3, 5, and 6.
2, 3, 5, and 6. Before the Ms. N. Bodolo, Learned, Standing Council Revenue Department, Assam, for respond number 1, and so for respond numbers 2, 3, 5, and 6. They have waited for some time to seek instruction. And seek preliminary instruction so as to appraise this court. Mr. N. Goswami, learned G. Assam has also made a similar request. In view of the above, this case for motion again after 10 days, so as to enable the learned department counsel to obtain instruction, preliminary instruction. One extra copy each be furnished to the learned standing counsel appearing in this case.
My lord, demarcation case number 48 oblique 22.
Is it not written in the writ petition?
My lord, it is.
Then they will file it. Yes.
My lord.
Ex gratia.
Yes.
Will issue notice. Heard Mr. W. Rahman, learned counsel for the petitioner, peruse the amendments made in the writ petition. The petitioner's son had died in a tragic road accident which took place on 03/09/2020. As per the notification, government notification dated 15/11/2014, the petitioner is entitled to claim ex gratia relief of an amount of rupees 2 lakhs. However, since her request for release of the amount has not been acted upon by the authorities, this writ petition has been filed. Ms. N. Bordoloi, learned SC Revenue and Disaster Management Department, Assam, appearing for the respondent number 1, and Mr. N. Goswami, learned GA, Assam, appearing for the respondent numbers 2 to 5, had both paid for 4 weeks time to obtain instruction in the matter. Prayer allowed, NOM 4 weeks. Since the respondents are represented, no formal notice, extra copies.
Obliged. I think that is item 3.
None appears for the petitioner on second call during the day. It appears from the record that several adjournments have already been availed by the petitioner at the stage of motion hearing. After going through the amendments made in the writ petition and the relief prayed for, it prima facie appears that this is a frivolous writ petition. As such, this writ petition stands dismissed for non-prosecution. As such, be that as it may, this writ petition stands dismissed for non-prosecution.
Item 4.
So I am for the respondent.
All right, none appears for the petitioner on call. During the petitioner, even during the second call in the day, Mr. R.K. Bhuya, learned counsel, is present on behalf of respondent number 2. Respondent number 2, Mr. N. Goswami, learned G. Assam, has appeared for respondent number 1. Stop. Record reveals that the petitioner's counsel was absent even on the previous occasion when the matter was called up before this court. As such, it is apparent that the petitioner is no longer interested to pursue this matter with any degree of seriousness. This writ petition therefore stands dismissed for non-prosecution. Yes, dismissed.
Item 21.
Second call during the day. During the course of the day, you can write course of the day.
May I please your lordship, my lord?
Yes,
My lord.
yes, what is the matter, Mr.
So, my
Choudhary?
lord, what happened in this matter is that, my lord, the petitioner, my lord, he purchased a plot of land, my lord. And my lord, after purchasing the plot of land, he saw that there was, my lord, no appropriate road, my lord, leading to his land, my lord. Then from those people who were, my lord, had land, my lord, by which he could get a road, he purchased some amount of land from them, my lord, and then he constructed his house and he was living there, my lord. Now, my lord, this respondent, my lord, a private respondent, she also purchased some, my lord, land beyond, my lord, the land of the, my lord, petitioner. And my lord, there was no road, my lord. And because there was no road, and she being the wife of a policeman, my lord, she complained to the ADC, my lord, and the ADC, my lord, entered into that dispute, my lord, without, my lord,
having any power to do that and started a demarcation proceeding, my lord. My lord, by abuse of the
But
process of
ADC have power of demarcation proceeding.
no, but then there has to be a demarcation case, my lord, with notice to me, my lord. A proper demarcation case has to be there, but then on my patta lands, my lord, and over, my lord, the lands which I have purchased for my own use, my lord, how could those lands be demarcated, my lord, by allowing somebody else to, my lord, use the lands? my
Which
lord?
ADC is doing it?
There is the ADC, my lord, Sunitpur, my lord, Tezpur, my lord, in my place.
It was named by party lords.
Which respondent?
3.
That's for number 3, my lord.
Then you find out and tell us after 10 days
Lords.
what is happening. We'll keep it for motion.
My lord.
But Mr. G. Chaudhary, learned counsel appearing for the petitioner, peruse the amendments made in the petition. The petitioner is alleging undue interference on the private land belonging to the petitioner by the respondent number 3 at the instance of respondent number 4 by misusing his power as the additional deputy commissioner of the district. First of Mr. Chaudhary submits that without even registering a formal demarcation case, the respondent number 3 is seeking to demarcate the land of the petitioner so as to extend undue favor to the respondent number 4. Mr. N. Goswami, learned government advocate Assam, appearing for the official respondents, 2 weeks time to obtain preliminary instruction and appraise this court as to whether there is any demarcation case registered, and if so, the particulars of the same. Full stop. Mr. Goswami to also appraise this court if the respondent number 3 has been involved in the matter in any form whatsoever. Full stop. Copy of this order along with 2 extra copies. 2 extra copies of the petition be furnished to Mr. Goswami. A copy of this order be also furnished to the learned government advocate Assam during the course of the day.
Lordship, in respondent number 1, that is department personnel has been given lordship. It should be Department of Revenue lordship. In respondent number 1 lordship in the case lordship. There is a wrong party lordship. Department Commissioner and Secretary of the Government of Personnel Department. It should be revenue lordship.
This is not a revenue matter because he has, my lord, exceeded his, my lord, authority. That is why the person has been department. My lord, can I pray for some protection, my lord? That he is regularly, my lord, following this man, my lord. He is a process server in the
10
court
days,
of
make
the
it 10 days.
district judge, my lord.
No, 10 days.
My lord.
We will not interfere in this matter, but just want to see what is happening. That's all. These are not, except for just seeing whether he is acting in an arbitrary manner.
My lord.
No other relief can be granted to your client here. These are all civil court matters.
That is why, my lord, that he should
Yeah.
not have, my lord. That
That's
is the
why we
reality.
asked him to find out.
My lord, my lord.
What else?
My lord.
Otherwise, we'll close this writ petition on the next day. We want to just see what is happening.
Lordship.
That's all.
Definitely, my lord.
And you obtain instruction from the deputy commissioner of the district.
My lord. I am deputy obliged.
My lord, this is for impediment, my lord, that private respondents, lordship will.
All right. Heard Mr. B. Chetri, learned counsel for the applicant. This IA has been filed with a prayer to impede the opposite party.
This opposite party 3 and 4 pace 4.
Opposite party numbers 3 and 4 as private respondents to the in the connected writ petition being WPC number 4714 of 2023. I peruse the grounds taken in the IA. Mr. S.S. Roy, learned counsel appearing for the
2 and 3.
yes, opposite party numbers. Opposite. Can you write like this? Mr. N. Goswami, learned G. Assam appearing for the respondent number 1, and Mr. S.S. Roy, learned counsel appearing for the OP number 2, OP number 1 and OP number 2. Have submitted that they would have no objection if the prayer for impediment is allowed. In view of the above and considering the grounds stated in the IA, the prayer for impediment is hereby allowed. The OP numbers 3 and 4 are directed to be impeded as respondent numbers 3 and 4 in the connected writ petition. Applicants to petitioner to file amended cost title, register to thereafter list the writ petition for orders. IA stands disposed of.
My lord, there is also a caveat, my lord, the council is there. I can serve the copy, my lord.
You serve the copy.
For admission, I can print 30.
On the last occasion, we have given a draft of the settlement. Now, my friend could have informed me yesterday also, but now he says that they have not agreed to that settlement.
They have not
they have not agreed to my draft settlement, but neither there is any counter proposal from them.
So it's not correct. We have given a proposal that we are agreeing to 70 lakhs. It's a not correct statement made by.
We are receiving.
What is it? This, no.
This is the matter, and let me, because I am the petitioner. This is the matter, my lord, which relates to that Indian Oil Corporation Limited doctor. Now, the sons and daughters are all major. The wife is a teacher of the central school at Duliaza. Now, I have challenged my termination order. In the termination order in this petition, they have got themselves implemented as respondents, saying that there are two orders of the court below, in one in respect of a domestic violence and one in respect of a under the Adoption and Guardianship Act, Hindu Adoption and Guardianship Act. So there are some monetary allowance given in those cases. So they want to say that so far any retirement benefit in regard to provident fund, gratuity, etc., they should be given 70 lakhs. And on the last occasion, my learned friend from the Oil India Limited has submitted that even if I get with all the interest and all, I'll get around 88, 89 lakhs. So only 18 lakhs would be remaining with me. I said that I can go at least up to 50 lakhs and at least give me those amount. Now they said they are adamant on having it as 70 lakhs. And your lordship knows that so far this provident fund gratuity, it cannot be liable to attachment from any orders of the court. If they have not agreed, then we have to hear this writ petition on merit. And in this writ petition also, there is an interim protection at the very initial stage, because when there was a joint account, and Oil India Limited used to do to deposit the money in the joint account. I am not given the information. The wife is given the information that money has been deposited. Immediately on the deposit, she withdraws my entire subsistence allowance during my period of suspension. So this court said that don't transfer the money. I gave a new bank account. The court gave that account reflected that account number in the order sheet. But in the meantime, what has happened? They have initiated a departmental proceeding against me and terminated my service. So there are two writ petitions initially. Now this pending writ petition is in regard to challenge of my termination. And in the meantime, I have superannuated from that superannuation date is also over. Now, so far my case is concerned, even if I succeed in this case, what I will be getting is that my retirement benefit. And if I succeed in, then notionally, I may get those financial benefit due to the illegal termination. And what led to my termination was that initially I came to Guwahati from Duliaza. My wife lodged a 498A case against me, saying that I am having an extramarital affair with one of these ladies working in one of the TV channel. And on that ground, I have been arrested and kept in detention for 48 hours. And Oil India took it as a nefarious activities affecting the social and moral atmosphere which has been vitiated in Duliaza and terminated me. But there was reason, my lord. Now it's too late in the day to say all those things, because my juniors have also played a role in it, that because I was going to be the chief medical officer of Oil India Limited. So today, if I have to argue on the writ petition, my lord, only thing is that I will get my retirement benefits, and if your lordship success determination order, notionally I will get a financial benefit. So far, my wife, daughter, I was reciprocated, because your lordship knows that so far provident fund, gratuity, etc., are not liable for attachment any orders. If they have got some orders, then they have to follow some other proceedings, execution proceedings against those orders where relief has been, financial relief has to be granted to it. And there also what has happened. Initially, there was mediation effort by this honorable court. We went on the mediation. That's why we did not pursue those matters, and all those orders are ex parte orders. I appeared, but on the final days, I did not appear. Now, since they have not agreed.
Mr. Patwari, is a middle path not possible? Because if the matter is heard on merit.
No, my lord.
Just a minute. Then the question of paying anything to your client may not arise at all. Keep that in mind. Because this is a serious matter.
But my lord, how under the writ jurisdiction, lordship is interfering with an order passed by the judicial magistrate first class under DPA.
Who is interfering?
This is
why service matter.
Yes, my lord, that is why I am saying we are only seeking a clarification. The Oil India authorities, in the garb of some interim order passed in the service matter, They are not complying with those two orders, my lord. We are not contesting the case on merits. We are only seeking clarification, my lord. 2013, the DB Act, JMFC Dibrugarh has passed the order. Till now, in the garb of that,
What is the order passed?
Lordship will kindly come to IA 2834.
No, this-
My lord,
this-
I'll just interrupt.
No, my lord, he has
No,
come. Let me
yes,
complete it.
yes,
Yes,
Let him,
he is not placed
No,
the
but he is a counsel.
you have had your time, Mr. Kumar.
Yes, let him say, because these are factually not correct.
Please
I'll
take your
point it
seat.
out.
Please take your seat. Yes, let him say, yes.
Lordship will kindly take up IA number 2834 of 2022. And Lordship will kindly come to page number 34. This order was passed, my lord, on 6/10/2015 in CR case number 510.
What is the order? What is the order?
Yes, Lordship will kindly come to page 34.
No, why don't you say what is?
My lord, 40 lakhs were directed to be paid to me
Mhm.
upon contest, my lord, by a direction of issued to the oil authorities, and till now they have not paid me.
So you take the 40 lakhs.
No, the 40 lakhs to the wife, and in a maintenance case, there is another sum of rupees. So if I count it, my lord, totally add it, it comes to 70 lakhs. That is what I am asking. The order passed by that line of court below. I am not asking. I am not even asking the interest accrued over the 10 years. My lord.
Those orders are not under challenge.
Those are not on challenge. He has only challenged the termination, but in the he has misled this court and take an interim order. Don't deposit my the retirement dues in particular account. And in the garb of that, oil is not complying with those two orders, my lord. How can that be possible? Two judicial orders, my lord, 10 years.
Well, may I submit? This is not factually correct. Initially, also they came for modification of this order. These applications were dismissed by this honorable court and fixed it for final hearing. It is not the first time this submission has been made.
All right, so no compromise solution is possible.
Yes, ma'am. We'll argue on
Matters
that.
will have to be heard.
Yes, ma'am.
Then when? After vacation?
Yes, ma'am.
After vacation?
Yes.
Merit, my lord, they will contest. I am only seeking a clarification from my lord.
Clarification regarding what?
Regarding that, they should pay the amount directed by the court below.
There
And
is
they,
already a status order of this honorable court.
no, there is
And
no
they have
status quo. There is only
that dismissed.
there is only an order. Don't deposit his retirement dues to the joint account. But the learned court below has not said that you pay to that account.
May I just read the line? In the meanwhile, status quo as on today regarding release of money to the petitioner shall be maintained.
But what is the earlier order? This is not the initial order.
116th order.
This lordship will go to the initial order.
In fact, your lawsuit order is also there saying that we should be custodian of the money. We should keep the money.
That is true. That is true.
Not
Money
all
will come.
information is coming now. It was all in open. These orders will pass.
No. When the first interim order was passed, I was not a party even, my lord.
Ask me to pay anyone, I'll pay them.
See,
Whoever have to pay.
there are some legal issues, but there are a lot of ego issues. Now, the problem is when one tries to blend law and ego together, it poses a difficulty. And the results are even more devastating.
Yes.
That is the reason an attempt was.
My lord, such attempt was made earlier. They are dilly-dallying the matter.
No.
What happens is the order will either go his way or your way. But
My lord,
whichever way it goes.
when your lawsuit is hard in merit, everything will.
My lord, this submission was.
I
I'm
heard
not making it
Mr.
was harmful.
Before Lion Senior Counsel is appearing for the writ petitioner, also heard Mr. H. Sharma and Oil India Limited appearing for the official respondent, Mr. G. Patwari.
For private respondent number 7, 8, and 9.
Has appeared for private respondent number 7, 8, and 9. After hearing the submissions made at the bar, it is apparent that a compromise solution in the matter between the petitioner and his family members, that is the respondent number 7, 8, and 9, is not possible. Under the circumstances, the only option left for this court is to decide the writ petitions on merit. As such, and on the request of learned counsel for both the sides, let these writ petitions be listed for admission hearing again on 13th of November 2020.
My lord, 13 may be a holiday. I'm just showing my, let it be on 14, my lord.
Let it be on 16th of 15th.
15th.
But let it not be treated as part heard anymore. Because the availability of the bench after vacation, I don't know.
So let it come up because we have your lordship is delaying. Let it depend, my lord, because again, my lord, we have to start from fresh.
And also you have to start from fresh.
Your lordship will fix it on 16, my lord.
16th, as per roster.
Deep aside, my lord.
My lord, for that, while saying so, I must show, my lord, how it is covered by giving a very briefly about the facts of the case, my lord. My lord, the pursuant to an NIT, being the most competitive tender, I was appointed, my lord, for a 2 years period by the respondent authority, which your lordship will find at Annexure 3, page 29.
Just 1 second, Mr. Barbara. So you are agreed by deduction of demurrage
Yes,
liability.
and as my lord, the things is kindly have a look at page 29. It is important because I was appointed as handling and page 29, the subject itself says appointment of handling and transportation contract ex railway ID Salapara, my lord, in the Borak Valley to FSD Badarpur. Now via web is so and so. So one part is transportation. There is a handling, different handling contractor at the Malala Salapara railway. So the handling responsibility is not there. Now, my lord, I commence the work. Till now, I successfully transported all the assigned food stuff from the railhead to FS. Neither any complaint nor any dispute. Almost from the beginning, my lord, FCI is unilaterally and without notice and in a most arbitrary unilateral manner, my lord, deducting the considerable amounts from almost every bill of transportation, which I have submitted. Purportedly as demarcation charge. Now, my lord, what demarcation charge is all about? My lord, it is this charge, my lord. It is the charge, my lord, inflicted by the railway for late opening of the wagons and receipt of the goods from their wagons. There are existing railway circulars norm as per which, my lord, I have quoted the relevant clause, which your lordship will find at page 37-38. Below, my lord, page 37 below. Free time for loading, unloading of various types of block rakes in the case of freight, terminal, sidings, steels, plants, goods sets, so and so. Now, your lordship will see in the box, there is a free time for loading. That means when the goods trains come, my lord, you get a free time of 3 hours. And for unloading 5 hours, and similarly different sort of, my lord, wagons. Then, my lord, come to next page, clause 3. Demurrage charge shall be levied at the rate of so and so per 8-wheel wagon per hour on part of detention of wagon in excess of permissible free time. The rates of demurrage charges prescribed above shall be applicable equally to all types of 8 wheels. And rates of demurrage charge in respect of 4 wheels and the rates prescribed for 8 wheels. Now, 3 below 3.42. The rates can be increased by, say, 2 times or 3 times or so on, and not necessarily 6 times at one go in all cases. In fact, railway may decide to levy variable rates like 2 times for the first 3 hours, 3 times for the next 12 hours, and so on and so forth. Now, I leave it here. What is it? Now, irrespective of any consignment, FCI issues an indent essentially 24 hours prior to reaching of the wagons. And this is given at my page 31. This is the type of wagons. indent, page 31. Actually, it is interdepartmental from manager movement, division office Silchar to the railhead in charge, indent allotment. It is for to inform you that as per FOIS, Freight Operation Information System, one so-and-so rake containing 58 wagons, XKLE, that is the loading railhead, likely to be arrived at Salapara on 31/8.
So you say it's a covered matter,
I say it's a covered matter.
covered by which judge?
My lord, I am saying, because the problem is why they can normally, my lord, the goods train arrive in the night hours, normally. Even here also, Bamli Maidan. And my lord, thereafter they are, it is the job of the FCI. They are the consignee. I cannot receive the goods. There is a procedure, my lord. FCI's personnel have to be there at the railhead with consignment documents. Wagons are sealed. Those have to be unsealed and all these formalities. I have no business there. But the harsh reality is, my lord, on numerous nights, my lord, the concerned FCI personnel, Babus, they don't attend the railway station at 2 o'clock, essential commodity. They go merrily in the next morning, 9:30, 10. Therefore, automatically there is a delay by 7-8 hours beyond the free time. And FCI inflicts the demarcation on FCI railway inflicts the demarcation on them. And they simply keep the buck on me. That is precisely the case, my lord. Here, it is in a case, my
No,
lord.
Mr. Barber, what I was saying is, will it require adjudication?
Yes.
This
Yes,
matter?
yes,
Yes, ma'am.
yes.
Then I will first have to take other matters which are fixed,
All right, my lord, I am here.
or
On
let us
some
have it-
hearing day, my lord.
I am here, my lord.
on a not miscellaneous day,
Day after tomorrow, my lord.
On third,
after tomorrow will not be possible. Next week.
third.
Third? What third?
I'm sorry, on today's third, 10th.
None, 10th, my lord, I have got some difficulty. Let it be on 9th, my lord.
12th.
12th. So my intimate matter will be disposed because my contract will, tenure of my contract will expire immediately after petition.
Heard Mr. A.C. Barbarel and senior counsel appearing for the writ petition. Also heard Mr. B.K. Singh, learned standing counsel FCI authorities appearing for the respondents. Is writ petition. It is submitted at the bar that this writ petition is ready as regards pleadings and can be taken up for disposal at this stage of admission hearing.
It is covered.
In view of the, it is also the submission of Mr. Barbara that the issue involved in this writ petition is covered by earlier judgments of the High Court as well as the Supreme Court. In view of the above and on the request of learned counsel for both the sides, registry is directed to list this case for admission hearing at a fixed title on 12th of.
Much right. It will take at least 1 hour, 45 minutes.
And 55.
Just check, it have contractual dues. It have given a bench 5 meter line. Just take a note and find out us.
May it please, your lordship.
Yes.
Lord, Sri Hari Mandir Nalbari, a religious denomination, will file this instant writ petition and the two orders, that is 22/7/2023 and 19/9/2023 issued by the district commissioner. Essentially, my lord, dissolving the executive committee and taken the management of the committee by themselves, which is the transgression of Article 26B as well as 26D of the Constitution. Now, my lord, I will take your lordships. The Article 26B and D, what it says.
First of all, who is the petitioner?
My lord, in this case, I am the petitioner.
Who are you?
My lord, I am the president and secretary of the Hari Mandir committee, my lord.
President and secretary.
My lord. In item 19. my lord.
The President and Secretary of which committee you said?
Sri Sri Hari Mandir, Nalbari, my lord.
So this committee is constituted by way of election
Yes,
for a period of term.
for 3 years.
And when was the last election held?
That was, my lord, it was expired on August 2022.
So thereafter you were elected, re-elected.
My lord, the election did not take place due to certain reasons. COVID and all that came in between. So, my lord, there are various reasons which it could not be held. Now, in this case, main question would be, my lord, whether district commissioner has any power to come and transgress this. Now, because in Article 26B, your lordship will find is very clearly defined. It has been prescribed who can come and under what position.
Constitution. 26B.
26B as well as D. As your lordship got my lord. Freedom to manage religious affairs, subject to public order, morality and health. Every religious denomination or any section thereof shall have the right to establish and maintain institutions for religious and charitable purposes. B, to manage its own affairs in matters of religion. This is very important. In this case, it happened. To manage its own affairs in matters of religion, there is no rider that the state legislature can enact any law in this part. Now, C, your lordship may skip. D, to administer such property in accordance with law. This is very important, my lord, because the state authority can come, provided there is an enactment by the state legislature, because it is open to them in entry, my lord, 28 of the concurrent list, my lord, Schedule 7, they have the power to enact such enactment, but I doubt whether, subject to correction to my information, there is no such enactment. Therefore, if there is no enactment, you cannot come in and administer the property. My lord, so far administering the property, they have the power, provided there is a statute. My lord, in this case, your lordship will find if your lordship sees the Endowment Act. I'll take your lordship to that. There is a specific bar where the district administration cannot. Straightway, I'll take your lordships to section 22. The Religious Endowment Act 1863. The section 22, your lordship can see. Government not to hold charge henceforth the property for support of any mosque, temple, etc. Except as provided in this act, it shall not be lawful for the central government or any state government or for any officer of any government in his official character to undertake or resume the superintendence of any land or other property granted for the support of or otherwise belonging to any mosque, temple or other religious establishment, or to take any part in the management or appropriation of any endowment made for the maintenance of any such mosque, temple or other establishment, or to nominate so and so, so and so. Now, under this act, your lordship can see, your lordship can look at, my lord, section 18. Before that, your lordship can see section 14. My lord. Persons interested may singly sue in case of breach of trust, etc. Any person or persons interested in any mosque, temple or religious establishment, or in the performance of the worship, or of the service thereof, or the trust relating thereto may, without joining as plaintiff, any of other persons interested therein, sue before the civil court, the trustee, manager or superintendent of such mosque, temple,
or religious establishment or the member of any committee appointed under this act for any misfeasance, breach of trust, or neglect of duty committed by such trustee, manager, superintendent, or member of such committee in respect of the trust vested in or confided to them respectively. Now, the power of civil court. And the civil court may direct the specific performance of any act by such trustee, manager, superintendent, or member of a committee, and may decree damages and cost against such trustee, manager, superintendent, or member of a committee, and may also direct the removal of such trustee, manager, superintendent, or member of a committee. Then section 18. Application for leave to institute suits. No suit shall be entertained under this act without a preliminary application being first made to the court for leave to institute such suit. The court on the perusal of the application shall determine whether there are sufficient prima facie grounds for the institution of a suit, and if in the judgment of the court there are such grounds, leave shall be given for its institution. Then section 19. Court may require accounts of trust to be filed before giving leave for institution of a suit, or after leave has been given, before any proceedings taken, or at any time when the suit is pending. The court may order the trustee, manager, or superintendent, or any member of a committee, as the case may be, to file in court the accounts of the trust or such part thereof. The court may seem necessary. Now, from this, your lordship has seen there is a transgression of constitutional provision, as well as, my lord, violation of the Religious Endowment Act 1863. Now, to fortify my argument, my lord, I take your lordship to a decision of the Honorable Supreme Court. My lord, reported
Mr.
in.
Datta, what is the fact of this case? What really are you challenging?
My lord.
First, let us see the facts.
Now, facts is very simple, my lord. It's a Mandir committee, an executive committee used to run the business. So far, the administration of business and day-to-day business of their ceremonies. Now, in that extent, my lord, the state authority has no role to play. There cannot be any enactment also, my lord. So far, in the concurrent list, they have the power to enact the law. But so far 26B, there's a emphatically, my lord, no, they cannot do anything. So for 26D, state has the power, because your lordship will find, my lord, Madras, Bangalore, they have the Endowment Act. They themselves, my lord, in this case also, I'll take your lordship to Madras government, they had an enactment. They have challenged particular section 35, 56, my lord, they have challenged, the Mandir committee has challenged. But that has, my lord, by virtue of that, what they wanted to do, the administration was tried to be taken for permanent. The apex court said you cannot do that. For a time being, if you can show that there is a breach of trust, there is a mismanagement, you'll have to justify that. Therefore, your lordship has seen in the, my lord, Central Act also, they have said you'll have to fulfill the breach of trust and all these things. Primarily, you'll have to bring up those things. Unless you can satisfy the court that there is a mismanagement or all that, you can't bring anything. You can't take this institution. Now, what they have done, not only, my lord, administration of property, that they have the power if there is a statute. If you do not have your own statute, you will have to fall back to the Central Act. Now, the Central Act, it has been said the DC could have gone to the civil court, he's an interested person. He has found, he is satisfied that there is a mismanagement. Now, that power he has before the.
DC is not an interested person.
No,
Interested
DC,
person means someone who is interested in the temple.
any person, I'm not talking about DC, since he has taken over the management, that means he is interested. He found that there is some breach of trust, there is a certain amount of so far financial irregularities, those things possibly they are saying. Now, it may happen in certain Mandir committees and all that.
Mr. Datta, I'm not trying to preempt you from arguing the case, but the other day, Mr. Chaudhary has also argued. You see, you are free to argue the matter, but, and I am willing to hear it, but it will take time. And it's not possible to pass any order before vacation. Be very sure about it.
My
Or if you want a See, the question is, you are saying the managing committee of the temple should run the affairs of the temple,
Yes.
correct?
My,
You are right in that. But if the order is stayed, the managing committee is not in office. The managing committee's term is expired.
yes.
So there will be a vacum, which the court will never permit, And the court will also not permit your clients to take over because you don't have any authority.
No,
You are
I'm not
in
saying
office.
that also.
So
Your lordship may
therefore-
suggest that ad hoc committee may be
Therefore,
constituted.
the shortest and the best way out here is, if you all agree, is that we can provide for a timeline to hold the election of the managing committees. And once the managing committee, elected committee comes into office, the deputy commissioner will hand it over. Because your argument on 26B and D are attractive. But please don't forget, it starts with subject to public order morality.
Well,
So
yes,
public order is, if it is a prima facie case made out, you are out for a long time.
well, opinion
because-
boards is, this is very clear. The
So if
public
there is an
order,
issue of public order, the deputy commissioner can step in.
but is there any situation of
That
public
we'll
order?
have to find out.
Is
For
is
that,
not, well, how they have come?
all right, then
Is it
we'll admit
totally a
it.
transgression of the
We'll
power?
admit it. Today it can't be decided, then that's what I'm saying. I'm cutting the long matter short.
My lord.
If you want to argue for whole day, I have no
No,
difficulty.
no, my lord, I don't have that
But
intention.
what purpose will be served? Because I will reserve the judgment and you'll get it whenever the judgment is ready. But prima facie, this is not a case for stay. I'm making very clear to you. Because I have read the order of the deputy commissioner. The order would have been stayed if there was a elected body in place. The whole thing would have been completely different. If the order is stayed, who takes over? Your clients cannot take over.
My lord, I
Who takes
respect,
over? You tell me that.
yes, I respect what is.
So that is the
political
only
norm.
problem here. Otherwise, yes, prima facie, all attempts should be made to allow the committee to run the affairs of the temple. Unless, of course, there are specific allegations of misfeasance, breach of trust,
yes.
criminal, then the law will take its own course. The court cannot come in between.
Yes,
But the problem today is none of the petitioners, in the other petition, he is a devotee, he cannot run the affairs. Your clients, their term in office has expired more than a year back. They cannot be brought back to office
no, that's
without
true.
holding an election. So either we go into the legalities, which will take time, or we look at holding election of the managing committee at the earliest. If both of you agree, I will ask Mr. Saikia what is his stand, and we can pass an order accordingly.
It's a very
Or
fair
else we
way.
will hear the matter.
My lord.
Today, a final hearing and disposal will not be possible. Mr. Datta, I hope you understood what
Yes,
is the
yes,
point.
very right.
Rest, pulling it from sides is okay. But at the end of the day, the court is stuck up here. Your clients cannot take over the management. And the court doesn't have any parameter to give it to anybody else. So under the circumstances, treating it as a public order issue, the deputy commissioner will have to run the affairs.
Just 1 minute.
Please confer, please confer. I am taking you a little fast in a fast forward mode.
My lord,
I could have said this after 1 hour, but that just to save some time of the court. That's it. You can be in a huddle outside and come back if you want.
Mr. Chaudhary will make his submission.
But after dissolution of the committee, my lord, the new committee has been constituted by the district commissioner. And the respondent number 6, being a minister, he was given the presidency of a subcommittee. But now he has been shown in the banner itself, etc., that he is acting as president at present. So, my lord, I appreciate your lordship proposition that regarding election. The election that can be held under the constitution of the Hori Mandir, madam. Under the constitution of Hori Mandir, no other than the executive committee can give the like membership or membership. Now there has been a mela of giving membership. So, my lord, under that situation, my lord,
Those go and challenge it in the
if election is held at present too, with those members, my lord, what sanctity will remain with the
We are
denomination?
not concerned. We are not here for strategic reasons. The courts will see what is the legal recourse and whether there is
Yes.
any violation of right. Who wins, who has a edge, who gets gains, who loses. That's not our
No,
job.
may I suggest, my lord, that till hearing of this case, my lord, court itself appoint a committee, my lord, for look after the administration of the denomination. Till the hearing case
Is there any prayer?
My lord,
You
yes.
made any prayer to that effect? Where is the prayer?
My lord, directly it is not there, my lord, but in the interim prayer, my lord, I am reading, my lord. During pendency of the writ petition, the order bearing so and so issued by the district commissioner Nalbari may kindly be stated, and further district commissioner Nalbari be directed not to issue membership, not to interfere with the functioning of the existing elected body. That is the executive committee in respect to the
Mr.
state.
Chaudhary, what I would like to actually tell you here, you make up your mind which way you want to go in this matter. I'm finding it a little amorphous.
we have-
What I remember in the first day also I told.
We have not made any complication, my lord. Only, my lord, that as per constitution, the earlier body can continue till handing over the charge, my lord, to the newly elected body. That is the situation prescribed by the constitution of Hori Mandir.
Where is it? Let us see. Where is the constitution?
Constitution, my lord, I am saying.
Your writ petition is
Yes,
number?
my petition, my lord. Page WBC 5013.
WBC 5013, page number?
My lord, 41. Paragraph 7 of the constitution. 7C, madam. As per the procedure laid down in the sub clause B of clause 7, the members shall elect the president or other office bearers. It is to be mentioned that the erstwhile general secretary shall continue in his office until the new committee is constituted, and after constitution of the committee, should be handed over to the new committee as within a period of 1 month. So, my lord, this is the provision.
No, but what about clause 9?
The term of the executive committee, certainly your lordship has rightly said, term that has been expired, my lord. But both should be read, my lord, to find out the true meaning, my lord, regarding handing over of
That's
charge.
right. So only
And,
interpretation that is possible is
My lord,
when the new
here-
committee is elected within
my
3
lord, here
years.
is the provision, my lord. If any member, aggrieved member of the committee, if they think that the term of the committee has discontinued, then my lord, they can have a requisition meeting by filing a requisition meeting before the president or secretary. And accordingly, requisition meeting that can be held. But here in this case, my lord, due to reason of the COVID-19 period, my lord, tenure, then nobody has come forward for a requisition meeting also. And that after the expiry of the term, that committee.
So why don't you then give a requisition and hold a general meeting of your committee and.
Yes,
proceed
that can be done, my lord. But at present, my lord, many persons have entered into the committee by illegal means, my lord. Now, after dissolution of the committee.
Which committee? Entered which committee?
After dissolution of the existing committee, my lord, new committee has been formed, and new committee has.
That is the interim committee.
Interim committee.
That
They have given all membership, my lord. These are unconstitutional, my lord, not in accordance with the constitution of Hori Mandir. They cannot do it, my lord. That is the problem. my lord.
So the new committee has given membership.
Yes, life membership, even renewal of life membership, that has been included, my lord.
If I have to speak out, lordship, I have to tell it the story from the beginning. How the huge money has been misappropriated. There has been no accounts for last 5 years. 2018, they got elected. Their term was over not in August 2022. It was over in January 2022. Not a single AGM had taken place from their taking over charge in 2018. Not a single account has been deposited. Everybody thinks it is their private property. Whoever, in whatever manner they can take the money, they are doing. The deputy commissioner in the meeting held in May 2023, lordship,
initially entrusted 3 officials of the government to investigate and find out the anomalies. That report, if Lordship is pleased to look at for once, everything will be clear if I'm allowed to place that report. All these other nitty-gritties are minor. How they went ahead.
We'll hear you, but Mr. Saikia, please respond to one query of the court.
Yes.
This committee which was constituted by.
Yes, that committee, there was a general meeting on 12th of August. It was decided there that they will renew the existing membership, just like the KYC, the bank does it, because there are a lot of non-existing persons also who are members.
Non-existing persons.
Persons as members. So therefore, the House decided in their presence, everybody was present. The former General Secretary is a part of the ad hoc committee. It is not that something is done behind their back. They are part of the whole decision-making process.
Meeting was presided by the district commissioner, not by the
At the
president
request of the
bank.
House, at the request of the House.
No
Not
request was there. That
in
cannot
our
be
affidavit, we have
established by
said
any facts.
the deputy commissioner has no business there otherwise. And in case of Kamakya Temple's case, Lordship, the Honorable Supreme Court directed the deputy commissioner to take over all the fund and maintain accounts. The reported case I'll place. And this Endowment Act is not at all applicable. It is not a protected act under Article 13(1) of the Constitution. Why they are obsolete act they are placing before this Honorable Court? First, they have to show that everything is gone as per the Endowment Act of 1863. There has to be a committee constituted by government. May I place that act first? They straight away went to Article Section 22. What about Section 3? A committee has to be constituted by the government that in that period of time. And on top of that, 1935, the Government of India Act, everything has to be protected. The Pre-Independence Day Acts and Article 13 also very clearly said, and Supreme Court recently in this judgment, Kamakya Temple's judgment, Lord, say very clearly said, these acts are not covering the endowments now. I'll place because that will take the full day's hearing.
When are you proposing to hold election?
The election is 30th. That chart I have given, and it was they were all present. Second last page, Lordship, that is the schedule. Tomorrow is the date of publication of the voter list. Page, Lordship will kindly come to page 120.
120.
120. And in all the meetings, everybody was present, Lordship. It is not that somebody is left out. Whether they are present members, past members, present executive, ad hoc committee members or that. A meeting held on 19 September in the conference hall. The schedule is there. After threadbare discussion, the following decisions were taken. The selection committee will submit the list of life members within 25/9. Publication of the draft voter list, life members will be done on 27/9. Claims and objections to be submitted from 2nd October to, that is so and so, up to 2nd October. Life membership fees to be deposited from 2nd October within 2nd October. Publication of the final voter list, that is 5th, tomorrow. Date of nomination 6 to 8, day after tomorrow. Then 11th has been fixed for submission of nomination papers, scrutiny of nomination paper 11/10. Date of
You're
withdrawal.
reading from page 120.
Yes, Lordship. It's a part of the affidavit, Lordship. 120, the affidavit filed by the deputy, the Chanakya Thakuria, one of the ACS officers on behalf of the DC. Additional ADC has filed the affidavit. And the election is fixed, Lordship, on the polling will be on 30th of this month. Have Lordship found it?
Just a minute. I'm
Returning officer, appointments.
There is an affidavit filed by respondent numbers 2, 3, 4, and 5.
Lordship, yes, that is.
Is that the one?
Yes, Lordship.
Page 120 is the
120 of the affidavit. Annexure 8.
Affidavit.
The timeline for holding the election, various stages.
Just take it for a minute.
Right. Lord, so far the facts is concerned, my lord, our submission is incomplete, my lord.
We'll hear it.
And
We'll
our
admit
main
it
case,
then.
so far as my learned friend Chaudhary's case, it is not maintainable.
My lord,
Because he is
I-
just a life member.
I have given reply, my lord, that in reply I have.
Yes,
justified
maintainability
how-
point has to be
how
decided.
I have got the locus standi to file.
So you are opposing the election fixed on
Yes,
30th of
yes, my lord, because they have no locus standi on the basis of a meeting dated 14/5/2023. That was a meeting presided over by the respondent number 6. And it was a meeting of the subcommittee, not Hari Mandir committee. And resolution was passed on 14/5/23 that request has been made to the deputy commissioner, Nalbari, that to take over the management of the affairs of the denomination. But that meeting resolution is not a resolution of the Hari Mandir committee. It is not a resolution of Hari Mandir. No request was made by the Hari Mandir committee to take over the management. This subsequent
But
development,
Hari Mandir committee has already lost its force in office.
my lord, lost its tenure is complete. That doesn't mean that he doesn't have any existence, my lord.
What existence you have?
Yes, my lord, because until and unless a meeting, general body meeting is held
Mhm.
and a new committee is formed and charge is handed over, till then that committee continues, my lord. This is the law, my lord, constitution of the Hari Mandir. So, my lord, while it was a process, my lord, for holding a general body meeting, then everything has been done, my lord. The subcommittee, as per clause 12 of the constitution of Hari Mandir, the subcommittee is is enjoying the delegated authority of the executive committee. They are under clause 13. They will have to submit the books and accounts of the Raj Puja of 2020 held in November, the 2022 held in November. But the respondent number 6 managed the general secretary of that subcommittee. He is a government official, and that is why he agreed to the everything agreed. He has agreed in accordance with the instruction given by the respondent number 6. And all the books of accounts, those were submitted before the district commissioner. So these books and accounts, your lordship may kindly see the clause 13 of the
But
constitution.
Mr. Chaudhary, your client is just a devotee.
My lord,
He's just a devotee.
my lord,
Why is he opposing the holding of election then?
I am opposing holding of election because I am a life member of that committee, my lord, Hari Mandir committee. And I have got my right to vote in favor for election of a member. The existing committee that was elected by me, my vote and other life members' vote. So why I have no right to right in respect of filing a writ petition to resist the others from interfering into the affairs of the religious denomination?
You have a right to file a writ petition. But that right of yours does not include the
My lord,
right to be,
the rest
right
part,
to
my
be
lord,
granted relief.
the rest part, my lord, the rest.
Yes.
Regarding granting of relief, it is your lordship, it is power of and domain under your lordship. But my senior friend, my lord, he will argue on that point. He has also filed a writ petition on behalf of the Hari Mandir committee, my lord. And in my petition, since because the administrative body did not come forward for filing a writ petition, that is why I, as a duty of as a life member, I filed my writ petition. And I make part all the executive committee members and other members are party here in my petition. Subsequently, this writ petition has been filed. And regarding holding of election, etc., my lord, in that writ petition, since being it is filed subsequently, so no affidavit has been filed in respect of that case. So the argument has not been made in this respect, my lord. So only thing, my lord, we are not against functioning of Hari Mandir by any committee, my lord. We are not against, but it should be done constitutionally. There is a constitution, it's a denomination. So denomination has got its own fundamental right. Others cannot interfere into the denomination's internal matter. That is my submission before this honorable court. And I can show my lord judgment into 1995 4 SCC. In my petition, your lordship asked me on the other day whether it is a denomination or not. So, my lord, in respect of it, man, I will cite a judgment, 1995 4 SCC, page 646.
Yes.
I am reading a small paragraph.
Yes.
In view of the aforesaid pronouncements of this court, persons who claim to belong to religious denomination envisaged under Article 26 of the Constitution can succeed in such claim only when they fulfill or satisfy the tests laid down therein, to wit, a collection of individuals who have a system of beliefs with regard to their conducive spiritual well-being, a common organization, and a definite name. All the three ingredients were our Holy Mandir, my lord, that satisfies the three ingredients, my lord. There was a collection of individuals, and they established Sri Holy Mandir in 1933, and they have got the constitution, my lord, to have its name as a denomination, Sri Holy Mandir Nalbari, and it was done. That constitution was adopted in 1978. So, my lord, it's a denomination, and it comes under the protection of Article 26B and 26D. So far, the 26B, my lord, in respect of maintaining religious affairs, the administrative body has the fundamental right without without any interference from any authority, my lord. Even no legislation can be made to take away such right. What right has been given under 26B and 26D, my lord. So far, the management of the property, etc., concerned, if there is irregularities there or any other things that happen, my lord, as per the Article 26, then it should be dealt with in accordance with law. There is no such law at present, my lord, to deal with, my lord, because there is no statute. State government in Assam, there is no statute in respect of it, my lord. Only the Religious Endowment Act 1863 that governs, my lord. And already that has been read before your lordship, that the section 20 bars taking over the management of the property itself. So at present, my lord, if your lordship is not inclined to dispose of the entire matter, then an interim arrangement is made, then may I pray before your lordship that the earlier body that may be allowed to perform the puja archanas there. That is that much of thing. The other thing regarding monetary matters, etc., a committee can be constituted by the honorable court, either from the executive side or from any other persons.
But this committee is not interfering in the religious part of it.
Religious part, because the existing committee has been ousted. My lord, now all chaos has been
No,
started.
but who is performing the puja, day-to-day puja? Who is doing it?
Only the general secretary and president of the executive committee look after these things, my lord. Religious.
That is correct, but
there is no
they don't perform the religious functions.
religious functions, my lord.
They perform it.
Yes, my lord.
Then
they
now
look-
who's,
the
this
appoint-
does not go and perform.
appointment of priest, my lord. It is not a denomination like Tirupati temple or Kamakya temple, my lord. Occasionally, whenever the puja comes, my lord, Durga Puja, Ras Puja, this is celebrated and priest is appointed. There is no permanent priest in this organization. So everything is looked after by the executive committee, and executive committee has been running the affairs since 2018, the present executive committee. So for the reasons of COVID, my lord, so many lapses have been done, my lord. Not only in Ras Puja, my lord, the Ras Puja committee, which has been held to be illegal committee at present, this committee, my lord, after expiry of the tenure, appointed the subcommittee to hold the November Ras Puja, my lord, in 2022. So, my lord, how it can be said at present, my lord, that this committee has been term has been over and they cannot act upon it. Only their stand is that 14/5/23 there is a resolution, and by that resolution everything has been taken over. And on 22/7/23 a review committee meeting was held, 9 officials were present in that committee, only 3 life members were present. So is it a committee of that resolution has passed before in presence of the Hari Mandir committee?
No, it is all understood, but Mr. Chaudhary, you are not being able to address the court on the most important question which has been asked again and again. If not this committee, then who? Who will conduct the election? You have missed out for whatever reason.
I have already submitted.
That's over.
I have already submitted, my lord,
Hmm.
and at the supervision of this honorable court, a committee.
That will also be a
Court
violation of article.
Your lordship has power to monitor the committee's conduct, my lord. Your lordship may appoint a committee in this respect, my lord. An independent committee, not my lord, the officials, my lord. The officials are under the response number 6, my lord. So that is a free and fair for a free and fair election, my lord.
Directly
And
DC to ensure that there is a free and fair election.
my lord, the district
That
commission.
will be the district commissioner will be treated as the nominee of this court and submit a report. What is your?
Yes,
problem?
sir, but
Let
you're
the
not-
present arrangement continue. We will ensure that the election is conducted in a free and fair. manner.
election should,
And submit a
my lord,
report.
election, we are not opposed to the election, my lord. Election should be held, my lord, but within the ambit of the provisions of the constitution of Hari Mandir, my lord. Not beyond that. Then now the new committee has been constituted. They have given so many members and they will be a member to elect a new body. That cannot be, my lord. Yeah, whatever the structure that was there, my lord, till expiry of the term of the earlier body, with those members, my lord, the election may be held, my lord. That is my humble submission. And to that extent, I don't have any objection.
Yes.
Page 129, lordship.
Hmm.
Various stages of election, 11, serial number 11, page 129. After detail, the date of election is fixed on 29/10. At
Yes.
serial number 10. Date of election 29, counting of vote 30/10. 12. The district commissioner Nalbari will appoint returning officer, presiding officer, and assistant returning officer. Accordingly, the deputy district commissioner Nalbari informed the house that the following officials may be appointed. They are already functioning, lordship. Returning officer Asutosh Deka, ACS, additional district commissioner. Assistant returning officer Srimati Sarmista Neo, ACS, election officer Nalbari. And presiding officer Pranjal Boro, ACS, circle officer Nalbari. So these persons, lordship, we cannot aspire any doubt regarding their integrity.
No, that's fine.
So election officer of the district has been who the election commission of India appoints and uses his service for holding the assembly election or the general election. So these persons are there.
No, these are all fine, but Mr. Saikia, one question that is troubling this court.
Yes.
And I will lay bare it so that you can address the issue.
Yes, lordship.
You see, let us come to the impugned order once, by which the committee was constituted. The order of 22nd. Which page is it? Page number? Page number 58.
Repetition.
58. Yes, the order dated 22nd of July
Yes, lordship.
2023.
Minutes of meeting related to Hari Mandir so and so.
Hmm.
So this meeting was preceded by certain events. Those events are very critical. If lordship is
All right,
pleased,
now you see, the point is, one can understand that the deputy commissioner has stepped in by noticing various irregularities, complaints of financial defalcation, etc. That we can appreciate. But this is to be treated as an interim committee.
and
To control the affairs till a elected committee assumes office.
yes,
Is that not correct? Is it not correct, Mr. Chair?
subsequently on 12th, a general body meeting had taken place.
No.
That 12 August meeting, lordship, I'd like to place.
Where is it?
12 August to Lund. August to Lund. Yes. 12 August meeting, the Assamese version is at page 106. Oh, there is a difference. It will be 114 in Lordship's book.
114.
Yes.
Yes.
So I'm coming to the English version. So that will be 106 or 7 translated copy.
Yes.
Proceedings of special general meeting. On 22nd of July 2023, in a special meeting held in the office of the District Commissioner Albury, under the chairmanship of the then District Commissioner Giti Moni Phukon, the Executive Committee of Hori Mandir has been dissolved and charge of Hori Mandir has been brought under District Administration. Subsequently, Srimati Bornali Deka, the District Commissioner, now newly joined, have convened a special meeting on 12th August by taking Nogan Deka and Madan Malekar as convener, who are members of Hori Mandir Committee. So they have issued the invitation, Nogan Deka and Madan Malekar. They convened the meeting. And Nogan Deka is the secretary of the earlier committee. So they were all involved.
Right. So this 22nd
It is
July 2023.
now here, Lordship, all the things have come into.
This committee has been superseded.
Yes,
by,
Lordship.
So you mean to say this is no longer existed?
I have stated in my repetition, this is not a Hori Mandir Melon. This is not a committee of Hori.
Yes, here Lordship will kindly come to page, that's last page, 6 resolution. Today's general meeting, all were present, including them, including all the persons who have filed the writ petitions. Today's general body unanimously decided to form an ad hoc committee to manage the temple until a new executive committee is formed. President Sri Joyanta Molla Borua, member Nogan Deka, who was a former secretary of that executive committee, and Madan Malekar.
You're reading from page number?
Yes, 114, if I am not wrong.
114.
6 resolution. It's a general body meeting where all the members were present. And I have gone through one of the resolutions where the normal puja activities will be done at serial number 10.
22.
Yeah, right. On the in Lordship, the previous resolution of 22nd, the previous page, Lordship will see serial number 10. Serial number 10, the meeting has also directed Secretary Hori Mandir Committee to submit estimated monthly expenditure to be incurred for day-to-day operation of Hori Mandir. Sri Nogan Deka and Madan Malekar will look after daily activities of Hori Mandir till the formation of the new committee. So all these activities are done by them now. The same persons who are before this honorable court. So the puja and nothing is affected. Only thing is that how come all this thing evolved? So for that we have to go to the meeting of May. That May's meeting in the month of May. And before that, I would like to place how this minister come into the scenario. The minister came into the scenario because in Lordship, in the writ petition, paragraph 9. So they invited the problem actually. The problem because the public representative cannot shut his eyes. Paragraph 9 of the writ petition. The aforesaid body continued during COVID-19 pandemic and the general body meeting could not be held in the month of August 2022 for stalling. This is their own perception. The meeting should have been done in January 2022. They themselves has given the extension of 6 months without having any meeting also. For stalling the different works relating to accounts, etc. by the auditors during COVID-19. Apart from this, one subcommittee was constituted by the aforesaid executive committee for celebration of Rakh Puja, which is the main function of Nalbari Hori Mandir Committee. Lordship knows Rakh is very famous in Hori Mandir premises. The executive committee, as a mark of respect, the local MLA of Nalbari, who is a minister of Assam at present, was appointed as president of the subcommittee of the Rakh Puja to be celebrated in November 2022. And the same subcommittee of Rakh Puja was as follows: President Jayanta Malla Borua, Working President Malakar, Vice President, etc. So they invited the public representative to be the president there. And this president, after entering into all these things, found that there is something very fishy, something very not palatable. So therefore, the meeting had taken place. On 14th May 2023, Lordship will kindly come to the affidavit filed by the government respondents at page 91.
Yes.
The meeting of 89 Nalbari Rakh Mahotsav under Sri Hari Mandir was held on 14/5. The meeting was presided over by the Honorable Minister. The President welcomes the members of the meeting whose names were listed so and so. Honorable Minister apprised the members regarding the seriousness of such issues, and after discussion, the following decisions were taken. Discussion and decision on transparency pertaining to financial transactions of 89 Nalbari Rakh Mahotsav under Sri Hari Mandir Nalbari, which was organized by the society, namely Sri Hari Mandir Nalbari. The account statements of 1989 Nalbari Rakh Mahotsav was placed in the month of December 2022, and during scrutiny, it was revealed that financial transactions pertaining to Bhaimorman Theatre, Smriti Granthak, Lottery Khel, circus were not incorporated. On enquiry, one of the members present today, namely Sri Nogan Deka, who is also the General Secretary of Sri Hari Mandir, stated that accounts pertaining to such financial transactions shall be handed over by December 2022, but he could not give reply to as to why such transactions were already not incorporated in the account statements. There was no COVID at that time. During discussion, it was further revealed that the incumbent president and general secretary of the society, Sri Hari Mandir Nalbari, has not prepared the account statements of the society from the financial year 2018 onwards, from the date of their taking over charge. Decision. The financial irregularities of the society, Sri Hari Mandir, are apparent, and hence it was decided that it may be brought to the immediate notice of the Deputy Commissioner, Nalbari, for further action in accordance with law, as it involves public money as well as public interest. Discussion and decision on illegal recognition as well as non-compliance of the statutory provisions of the organizing society, Sri Hari Mandir Nalbari. The members present today also expressed their concern regarding non-compliance of the statutory provisions by the society, namely so-and-so, which organized the 89 Nalbari Rakh Mahotsav. It was revealed that as per Article 9 of the Constitution of the Society, the tenure of Nalbari Hari Mandir is 3 years. However, the present committee was constituted more than 5 years ago, and continuation of such committee without election is illegal. Hence, it is necessary to dissolve the present committee and constitute another committee as per law, with a direction to the present committee to place the accounts, including all past financial transactions, immediately. In this regard, it was brought to the notice of the financial statements such as loss and profit accounts, balance sheets were not audited by chartered accountant from 1/4/2018 onwards. It also revealed that neither the general body meetings nor the special meetings as per constitution of the society were held by the present committee of the society. Not a single year they have conducted any meeting. Moreover, even though the constitution permits membership drives for inclusion of new members, the present committee is not allowing the same. The present committee is also carrying out various construction activities at the whims of the presidents and the general secretary without consulting any other member, and the expenditure pertaining to such constructions were not placed before others in spite of demands to that effect. Further, the president and general secretary, in spite of several requests, are not taking any steps for renewal of the registration of the society. In this regard, the members also expressed their desire to request the Deputy Commissioner Nalbari to supervise and monitor due compliance of all provisions and procedures of the society in accordance with law by following the constitution of the society, including preparation, computation of the financial statements. Decision. The non-compliance of the statutory provisions by the organizing society Sri Sri Hari Mandir Nalbari are apparent, and hence it was decided that it may be brought to the immediate notice of the Deputy Commissioner Nalbari for further action in accordance with law, as it involves public money as well as public interest. Article 26 also permits that, Lordship, subject to public order, morality, and hygiene. So this comes. Thereafter, the committee was constituted. Second page. A committee was constituted. Resolved that a deputy will be requested to constitute a team with such other members as may be decided along with the following members suggested from our end, namely Sri Umesh Chakraborty, Madan Malakar, Monu Chaudhary, Horat Kolita, Amal Deka, Nolini Sil, Nogen Deka, Horen Haloy, and Keshav. Such constituted team shall supervise and monitor the preparation of financial statements pertaining to all activities, including Nalbari Rak Mahotsav, and also to inquire and take such other actions as may be required about financial irregularities, if any, by the society. The Deputy Commissioner will be requested to ensure through the aforementioned proposed team the compliance of statutory provisions of the organizing society, including renewal of registration of the society. Next page, the constitution of the verification committee. In pursuance of the meeting held and so, a monitoring team is constituted. These are the persons. The ADC of Nalbari, then the Assistant Commissioner Nalbari, Finance and Accounts Officer, DC Office Nalbari, Local Audit Office. So these are all neutral persons, Lordship. They do not have any interest in the, rather the Deputy Commissioner also had no interest. He or she was requested to come and take over.
No, I have understood these things. Just two
Now,
clarifications,
yes.
just two clarifications. You see, I find that there is one committee where the district commissioner is the chairperson. That committee.
It was over because 12th August in the general body, 3 members committee was constituted, ad hoc committee.
Right.
They are now continuing the whole process.
That 3-member committee is now in the helm
Including
of.
the general secretary recently.
This is not a general body meeting, my lord.
Special general body meeting.
No, not special general body meeting.
They were present.
Who called, my lord?
Who called? Nogen Deka
My
called.
lord, after
Madan
dissolution,
Malakar called.
after dissolution, there was no general secretary or president.
These are not matters the High Court will go into. So the committee headed by the deputy commissioner is no longer. in
No,
existence, according to-
absolutely
No, my lord,
incorrect submission.
Maintainable there.
My lord, 14/5/2023, there was no resolution to take over the management by the deputy commissioner.
It was not
That's
taken.
Yeah, thereafter also, my lord, 22/7/2023, the meeting held. Only 3 members of the Hari Mandir present. Even president of the executive committee was not here.
Mr. Chaudhary, you are not understanding the basic query. You may have grievance on that count, but that is not a matter subject matter.
We have challenged this jurisdiction, my lord. Whether the district commissioner can interfere into the matter of the denomination. By a resolution,
Yes.
if constitution persists.
We'll hear it.
Yes, my lord, entire matters to be heard, my lord. Otherwise,
After your.
Absolutely no problem, Lordship. Lordship, the things is going on smoothly for the election. If
Well,
at,
smoothly, according to them, for their.
because they do not want to have any new persons.
For their interest, my lord, it
They
is going on
also do
smoothly.
not want that
But we are
the
a-
identity of the existing.
Heard Mr. You're right.
Lordship, if I am allowed to place the financial report,
No, we'll not.
it
go
will
into
clear everything.
Let the elections be held.
Yes, Lordship. I am highly obliged for that.
My lord, election, my lord, if they hold the
Subject
election,
to subject to
Yes,
further. order
yes,
passing.
subject to outcome of the writ petition, my lord, we will accept that. But if writ petition is disposed of, my lord, after 5 years, then no purpose will be served, my lord.
Why after
That is why I have submitted before.
From 18 to
committee
23, no elections, no
and-
meeting,
An independent.
no objection.
An independent committee may be constituted at the, by order of this honorable court,
Right
and
now, I'm not. passing any order.
The other day I gave a
Malad,
commitment that no FIR will be filed. Now we are going to
my
file
lord, we
FIR.
have prayer for interim order, my lord. Either it may be disposed of or it may be rejected, my lord. Order may be passed, my lord, because it is a consideration for interim order, my lord.
Okay. Take down, heard Mr. D. Chaudhary, learned counsel appearing for the writ petitioner in WPC number 5790/2023. Also heard Mr. F. Datte, learned senior counsel, assisted by Mr. S. Datte, learned counsel appearing for the petitioner in WPC number 5013/2023. Mr. D. Saikya, learned Advocate General Assam, assisted by Mr. E. Nath, learned Senior Government Advocate Assam, has appeared on behalf of the respondent numbers
2, 3 and
2, 3, and 4. Mr. B. Chaudhary
Item 55, I'm appearing for respondent number 6.
is present on behalf of respondent number 6 in item 55. Who is appearing for state of Assam?
We are appearing.
1, 2, 3, 4. 1, 2, 3, 4.
We are for the state of Assam.
1, 2, 3, 4. Yes. Understood. In both these writ petitions, the notification dated 22/7/2023, by means of which the district commissioner of Nalbari had constituted a committee to run and manage the affairs of the Hari Mandir of the Sri Sri Nalbari Hari Mandir has been put under challenge. Internally are contending that the impugned notification is in clear violation of Articles 26 bracket B and bracket B and bracket D of the Constitution of India. Full stop. The learned counsel for the petitioners have also prayed for an interim order suspending the operation of the notification dated 22/7/2023 and also for 23, thereby restoring the office bearers of the earlier managing committee who are the petitioners in WPC number 5013 of 2023. The learned senior counsel, Mr. S. Datta, has vociferously argued that the district commissioner of Nalbari did not have any authority or jurisdiction under the law to interfere in the affairs of a religious denomination such as the Hari Mandir of Nalbari, and therefore the impugned order is per se illegal. Full stop. Joining issues, Mr. D. Chaudhary, learned counsel. there were other devotees, including the former general secretary
Yes,
of the committee, which of the
Ad hoc
executive committee, which was a part of the said committee. However, by referring to the resolution adopted in the special general meeting of the committee held on 12/8/2023, Mr. Saika submits that a three-member committee headed by three devotees has since been constituted, and they are running and managing the affairs of the committee since then, without the interference of any public authority. Full stop. Mr. Saike has also invited the attention of this court to the notification dated 19/9/2023, issued by the District Commissioner Nalbari, to contend that the election of the managing committee of the Hari Mandir has now been fixed on
29th.
on 29th of October 2023, and a detailed schedule, including the date of submission of nomination, scrutiny, etc., has been laid down by the district commissioner. Under the circumstances, submits Mr. Saika, if any interim order is passed at this stage, the same would delay the election of a new managing committee of the Hari Mandir. Full stop. As such, the learned AG Assam has opposed the prayer for interim relief in this case. Full stop. I have considered the submissions made at the bar and have also gone through the materials available on record. Full stop. It is not in dispute that the earlier managing committee has lost its term in office, and therefore, even if the notification dated 22/7/2023 is suspended by this court, even then, they cannot come back to office and hold the elections of the new executive committee. Full stop. Furthermore, it is apparent from the materials on record that by the resolution adopted in the special general meeting of the committee held on 12/8/2023, this three-member committee headed by Sri Jayanta Malla Borua, the local MLA, has taken over the ad hoc management, the function of ad hoc management of the committee till the election is held, and the elections of the committee has also been duly notified by the district collector. The resolution dated 12/8/2023 is not under challenge. Under the circumstances, I find force in the submission of Mr. Saikya that issuing an interim order at this stage would further delay the process of election of the managing committee of the temple. Full stop. Situated thus, the prayer for interim relief is hereby rejected. It is, however, provided that the district commissioner Nalbari would ensure that the election of the committee as notified on 19/9/2023 is held in a free and fair manner, and by observing the provisions of the constitution of the Hari Mandir committee, and the results are declared as per the schedule. The election of the new managing committee be notified accordingly, but the same would be subject to further orders that may be passed in these writ petitions. Issue notice in WPC this matter, WPC 5013 of 2023. Since the parties are already represented, no formal notice is required to be sent. Extra copies of the writ petition be furnished to the learned departmental counsel office to list these cases together for admission hearing on 10th of November 2023.
Please, Your Honor. In this matter, Your Lordship, the husband of the petitioner was died due to electrocution, Your Lordship. And an affidavit has been filed by the respondent number 2, that is the chief electrical inspector, Your Lordship. And he has submitted an inquiry report, which was conducted as by the Honorable Court direction, Your Lordship. As by this inquiry report, Your Lordship, as page number 44 of the affidavit, Your Lordship, paragraph number 12, causing leading to the accident, and paragraph number 13, that is contravention, where they have mentioned that from the above facts and circumstances leading to the accident, it appears that there occurred violation of regulation 12.1 and 13.1 of the Central Electricity Authority, measures regulating to safety and electricity supply, regulation 2010, on the part of the EPDCL, that is Assam Power Distribution Company Limited, Your Lordship. So there is violation on the part of that.
In this regard, I need to obtain instruction whether the EPDCL will prefer an appeal under 162 subclause 2 of Electricity Act, my lord. On the next Wednesday, I will apprise the court, my lord.
No objection.
Mrs. Buyal and counsel for the writ petitioner has invited the attention of this court to the report of the electrical inspector annexed as annexure 1 to the counter affidavit filed by the respondent number 2. At this stage, respondent number 2 to submit that the negligence on the part of the board, on the part of the EPDCL authority is established in the said report. At this stage, Mr. V. Das Nanak, counsel representing the EPDCL authority seeks 2 weeks time to obtain instruction on the point as to whether the EPDCL authorities would prefer an appeal against the report and appraise this court. Mr. N. Goswami, Leonard G. Assam, and Mr. K. Gogoi, Leonard. You are there? No. Respondent N. Goswami, G. Assam, respondent numbers 1 and 2 is also present. On the request of the Leonard SC EPDCL, this matter stands adjourned for 2 weeks.
My lord, perhaps, my lord, it directs me first to serve a copy of the report, my lord, in order to enable us to obtain instruction.
Copy of the counter affidavit filed by the respondent number 2. Who is appearing for respondent number 2? Be furnished to the Leonard SC EPDCL.
I'm obliged.
Obliged.
Doctor, this is regarding the establishment of fecal sludge treatment plant at Gwalpar district. My lord, in short, a treatment plant, fecal sludge treatment plant was to be established in Gwalpar district. My lord, the contention of the petitioners here are that they are not opposing the plan itself, but they are opposing the vicinity at which it is being created, my lord.
So, we'll list this case along with some matters pending before the green bench of the same subject.
Even Lordship, that particular plant is operating in July 2023, 1st of July, Lordship.
My lord, my petition has been filed since the initiation of the plan. My lord, the problem is that the act envisages 200-meter minimum distance from the vicinity of the human habitation. That has not been followed, my lord. So, my lord, this has to be.
Mr.
J. Singh,
J. Singh, Leonard counsel is present on behalf of the petitioner, Mr. K. Gogoi, Leonard. You are from CGC.
I am for Lordship here as a Gwalpar Municipal Board, Lordship, as one of 4, Lordship.
Leonard counsel is present for respondent number 4. Mr. N. Goswami, Leonard G. Assam is present on behalf of the respondent numbers. 1 to 3. 1 to 3. The issue involved in the writ petition pertains to setting up of a fecal sludge treatment, FECAL, fecal sludge treatment plant. According to the petitioner, the plant established in Nagaon is in violation of the requirements of solid waste management rules, 2016. The respondents' counsel have however denied and disputed the same contention. Be that as it may, after hearing the submission of legal counsel for both the sides, this court is of the opinion that this matter would call for deeper examination. As such, admit the writ petition if the parties are already represented. Informal notice is required to be signed in this. Extra copies of the writ petition be furnished. No, extra copy is not needed. Let this writ petition be listed for final hearing in the second week of December 2023. Parties to exchange pleadings in the meantime.
Matter also. Matter is relating to the no confidence motion, my lord. In fact, my lord, out of 14, 30 members against me. But the only question was page 37. But in the meeting, when some outsider came and I made a protest, my lord, that was not addressed to my page 37. On the same day, same time, madam, within the course of the meeting, I have submitted it to the Deputy Commissioner, CEO, etc.
So your client was the president of
President of Anchalik Panchayat.
Anchalik Panchayat.
Initially, they might have on 25/10/21, they bought first time they bought a recusal notice that failed. We came before the subsequently they changed the resolution. We came before the court, this honorable court interim protection that is still pending. Again, they have got the present one. So that has now become infectious when the present one 2023 present of the requisition. I permitted them to hold the meeting, madam. I have given approval also, madam. My only question, madam, is they won, my lord, they are, because of your worship knows how many benefits are there. And he was not actually willing to, that is agree with their demands, my lord. So in the meeting, madam, initially, ultimately 13% voted against him. That is how they, but because of the influence of the outsiders, madam. And on that day, during the course of the meeting, madam, I made a protest. And thereafter, madam, again, Vice President now has taken over charge also, madam. When the case was, my lord, the notice was issued. It was,
What is there for the lead court to
my
decide?
lord, only I am on page 37 that has not been looked into by anyone, my lord. I know, my lord, where I stand, my lord. I know it. But 37, my lord, at least, right, I have made some grievance, my lord. And immediately on that.
But what will he do? He cannot bring him back to office.
No, back means, my lord, at least if it is found that really some outsiders are there, my lord. So naturally, there was no free and fair election was there, my lord.
No, it's not
That is the
election.
only reason, my lord, I have only,
It is not election.
no confidence motion, my lord.
There is-
Voting took place. my lord.
Yes, then
So voting took place, but go to the influence by the outsiders, my lord. That is what is my case, my lord. Threatening was there, signature was there, everything. That's what I have stated. my
we'll hear it in November along with the other matter.
lord. My lord, December, my terms are going
Today
to.
not possible.
It is still, it is there. I know where I stand also, my lord. But
Nothing in
December, my term is also going to over. Already by this time, by sense, by
That would be
president.
more honorable than getting.
Or let them see if something can be done. Authority also may look in the matter, my lord. I'm not saying I'm
You
the.
can't just say like this, this will require. You see, the point is, this is done through balloting, vote.
Right.
Everybody is under influence in the voting process.
But in during the course of voting, my in the voting ball hall itself, my lord, influence the outside, my
What
lord.
is your stand?
What is
Stand,
my
my lord, the members are also present, my lord. They don't have any grievance that they were influenced, my lord. And whole the process, my lord, was videographed. And this is the pen drive, my lord, where the videos are there. And absolutely wrong, my lord, submission of the petitioner, my lord. The pen drive contains the videos of the entire proceeding, my lord. There were no influence, secret voting was done properly, my lord. Therefore, no, they don't have any case. my lord.
Let them say, my lord, if
My
done
lord,
properly.
I can.
What prevented them?
Has anybody filed affidavit here?
No. For last 1 year.
Original record is here, my lord. I have not filed affidavit.
2 weeks time. My prayers 2 weeks time.
This prayer is coming on long, since long back, my.
Otherwise, I can hand it over the pen drive, my lord, containing videos.
This court did not pass in time, what I'm saying, the subject to outcome of the petition, my lord. That the election of the vice president. Since from Cooperative pending, order to go ahead.
On 21st February, since then, I am the president of.
That's true, I'm not denying that. Since that is pending till today, they have not filed any affidavit.
All right, last chance to file
Yes,
affidavit.
yes.
There's nothing in your case.
That's, I know my-
Richard Chaudhary, I am senior counsel, listed by Mr. F. Bobri and counsel for the petitioner. Also heard Mr. S. Daftar and SC PNRD Assam who submits that the original records are available. And as per the electronic evidence available with him, there has been no influence on the voters by any outsiders. Mr. P.K. Dekal and a counsel appearing for the Respondent number 19, who is presently discharging the duties of the president of the Anchalik Panchayat, prays for 2 weeks further time as last chance to file affidavit. Prayer allowed as last opportunity. On the request of Mr. Chaudhary, let this matter be listed again after the ensuing puja vacation along with WPC number.
Along with WPC, it already annexed, it is there, my lord.
Annexed one.
The double 603 21.
6603 or
21.
2021.
Obliged.
May I please? My lord, here in this case, the 10 petitioners before your lordship, they are the shareholder of a Shombai Committee, known as Katwal Rupuhi Shombai. Last election of the Shomiti was held in 2013, and normal election was due in 18, but no election, and accordingly election notification etc. was published. We participated in the process, we filled up our nomination form etc. But subsequently, it was on the ground of law and order situation, my lord, it was withheld, and till date, no election.
Lordship, we have filed our affidavit, my lord, in paragraph number 11 of our affidavit, page 39, running page. My lord, may kindly have a look, page 39.
Our case is that on the basis of earlier notification, election should be held. And by filing their affidavit, they said they will go for fresh election.
Lordship,
fresh
paragraph
election.
number 11, my lord, page 39. That regards the statement made in paragraph number 16 of the petition, the deponent begs to state that the preparation of the voter list is underway. And my today's instruction, verbal instruction from the air says that the preparation of voter list is completed and they will undertake the AGM shortly. This matter is pending before this honorable court. I have not issued any notification.
Paragraph
By directing them to hold AGM.
Of course, my lord. And paragraph 10, they said they will refund. Our case was that according to 2018 notification, election should be held. They said they will go for fresh, we have no objection. But they said our nomination deposit form, fees deposit, they will return it. So that direction may be, in paragraph 10, they have said that they will return our nomination fees.
All right, I heard Mr. So-and-so learned counsel for the petitioner, also heard Ms. M.D. Bora, learned SC Cooperation Department, Assam, appearing for the respondent number.
1, 2, 3, 5, and 6.
1, 2, 3, 5, and 6. The writ petitioners here are the members of, are the shareholders of,
Katwal Rupuhi Shombashi.
Khatwal, bracket Rupohi, bracket Samabhai Samiti, situated in the district of Nagaon. The Samabhai Samiti, a registered cooperative society situated in the district of Nagaon. Full stop. According to the writ petitioners, the AGM election of the Samiti, which was earlier notified on 12/1/2018, has not been held till today. Full stop. Hence this writ petition. Mr. So-and-so further submits that his clients had submitted nomination paper by by depositing the requisite fee. However, due to non-holding of the AGM as per the order dated 12/1/2018, the notification dated 13/1/2018, not 12. The petitioners could not participate in the election, nor have they been refunded the fee deposited by them. Full stop. Next, Ms. M.D. Bora, learned SC Cooperation Department, on the other hand, has invited the attention of this court to the counter affidavit filed by the respondent number 6 to submit that during the pendency of this writ petition, the preparation of correct voters list has already been completed, and therefore a fresh notification will be issued shortly, notifying the AGM election of the society. As such, Ms. Bora submits that his writ petition be disposed of with a direction to that effect. Full stop. Mr. Ayuddin has also agreed to the said order, but has sought refund of the nomination fee earlier submitted by his client. Full stop. In view of the statement made in para 10 of the counter affidavit filed by the respondent number 6, it is clear that the respondents are willing to refund the nomination fee to the petitioners. As such, no further direction is required to be issued at this stage. Save and accept, providing that the respondents shall notify the election of the AGM, notify the AGM of the election of the society as expeditiously as possible, but not later than 4 weeks from the date of receipt of certified copy of this order. Upon such notification, it will be open for the petitioners to submit their nomination in accordance with law is advised. Writ petition stands closed.
Deeply obliged, my lord.
May I please? My lord, the petition before my lord is a class 1 contractor. And my lord, on 5/11/22, he has to move around the state. My lord, he's originally from Borbothar area. The police or the officer in charge called him and said that we are providing you security because there is an IB input which has been communicated by the SP that there is a threat to your life, to me and my brother, my lord. Thereafter, my lord, whenever I go there, they give me a security, the temporary security is given. I approach the authorities that if this be the position, then I'll have to, because they have a committee, which committee, my lord, determines how to do it. Then when nothing was being done, I approached this honorable court, and on 15/3/23, while issuing notice, this honorable court wanted the production of the materials on which, my lord, this threat perception was, my lord, the threat perception was determined. Those materials were.
You are unhappy with the security given to you?
No security has been given to me now. Temporary security, when I go to Tinsukia, earlier it was given to me, my lord. Now that permanent security, which I am entitled because of this allegation, this threat perception against me, this is not being provided to me, my lord. So my movement has become restricted, my lord.
Yes, what do you have to say, Mr.
My lord, if your lordship goes to paragraph 8 of the petition, my lord, lordship will find they want permanent PSO. My lord, the SOP doesn't provide for any permanent PSO. It provides that threat perception assessment will be made from time to time, and they themselves have annexed the SOP, which said every 6 months there will be an assessment. Based on that, it will be provided. So if he wants a permanent PSO beyond the SOP, my lord, this is something possibly.
My lord, you give me a security. I'm not asking beyond the rules, my lord. I'm not saying beyond the rules.
Why don't you file your affidavit?
My lord, only thing is my whole movement, because around 6 months have passed, my lord, till the last date of listing. I had a talk with him also. My lord, the situation is so such that, my lord, he is not in a position to move. If my lord can, only that instruction, if that is placed before my lord, if there is nothing, fine, my lord, I am free. But if there is something, then they will have to act in terms of their own guidelines. If my lord can have.
My lord, the copy, my unfriend says he was not provided with extra copies, etc. Lordship will give us 1 week's time, we'll bring some instruction.
Only that much, my lord. Something is there.
Senior counsel appearing for the writ also heard Mr. D. Mavinda, additional AG Assam, assisted by Mr. M. Setia, learned counsel appearing for the respondents, who seeks a week's time to file a short affidavit responding to the prayer made in the writ petition. In view of the above, let the writ petition be listed after the affidavit is brought in the court.
My lord, if not the affidavit, at least that instructions before my lord will also do. My lord will have a date next week, any date.
No, fixed date will be after vacation.
But the man will be.
There is no such urgency in these matters.
Fine.
What this PSO business? One PSO will give him all security.
No, not one, my lord. There would be 2, 3. That, my lord, it's not status.
2, 3.
It's government that guidelines, my lord. And I get it when I go to Tinsukia, my lord. Why are they providing me that?
Then he should be happy.
Withdraw that from him also.
Yes, sir. I think I will.
Why are you giving him only in
My lord.
Tinsukia? That is discrimination.
We'll do that.
You maintain the same
Will
thing.
convey,
that
my
you-
lord.
That Tinsukia one, my lord, let them allow it.
What is the threat? What threat you have?
My lord, I'll be kidnapped.
And how, what is the principle, Mr. Nair, on which the courts can pass this order?
No, my lord cannot. My lord will not.
Then?
The authorities have to act, my lord, on their own SOP.
They
have
have
an SOP.
acted, when they acted in
No,
your
no, no,
favor.
my lord, that
then
was,
you are
no,
happy.
no, that is different. That is only a temporary measure. With that, they have to consider whether he has to be given a security for the state whenever he moves. That consideration they make, and they say that there is no threat perception.
I'm not
That's
convinced.
the,
You see,
well, that's the SOP, my lord.
when the public authorities are compelled to go and discharge functions which endangers their life in some way, it is understandable the state gives round the clock.
My lord, page
For
42.
private individuals.
No, no,
they
no, my
will
lord.
do
Page
all kinds
42
of business.
businessmen,
Uh,
page 42 businessmen who are under threat from militant organizations.
They will do it as per their own SOP. There's
Yes.
nothing for the court to do.
Nothing,
Just
my lord.
tell them to
I only
do some
want
other
them to
business.
act as per the SOP.
Who knows what kind of activities?
My
they
lord
do.
can dispose of the matter, directing them to undertake a threat perception examination and then pass orders, my lord.
Let them put their stand.
Lodge.
Lordship, the matter pertains to acquisition of Miadi Patta land by the Jorhat Municipality Board, Lordship, without following due process of law. Lordship, no acquisition process was being followed. No notice was served upon the co-pattada 2 and 3. By way of simple notification, Lordship, they have taken my Miadi Patta land and declared it as Municipal Board Road.
Where is the notification?
Lordship, at page 83, Lordship, the original version, the Assamese version. Lordship, translated copy, Lordship, there is one typographical error, but I have a corrected version of that translated, Lordship. I mean, based on record, Lordship.
Page
83, Lordship. Page 83, this is a Lordship translated copy, corrected translated copy.
No, but this is to do with the road.
Lordship, that's what, Lordship, there is no whisper. Lordship, what has happened? Lordship, this aftermath of this notification is very, Lordship, horrifying. Lordship, they have laid block bricks in my land. I have annexed photograph. Lordship, may kindly have a look at the photograph at page 126,
How can the writ court interfere in this matter?
Your Honor, they have taken over my land. Lordship, Lordship, kindly may have.
But this notification does not say so.
Your Honor, they have made the notification in such a way that it doesn't give a clear picture, but they are interfering. Lordship, kindly have a look at page 126. They have laid broad bricks, and there cannot be any public road, Lordship, which will run through my veranda, Lordship. My one part of the house falling.
See, your client has to wait for 2 years.
Lordship.
I'm telling you why.
Lordship.
You will pursue this matter.
Lordship.
Someday the court will be bound to give a verdict.
Lordship.
Court cannot give a declaration.
Lordship.
So the court will say, I'll dismiss it. Then you will say, then allow me to pursue the civil remedy. That stage will come after 1 year, 1.5 years. Then you will withdraw this writ petition. Then you will go to the civil court. It will take another 3 months to file a civil suit. Then the civil court will hear the matter. Then the other side will come and file written statement. By the time the matters are before the actual court, which will require evidence,
Lordship.
because the notification does not say anything about it.
That's what.
Then you have to file an application for an Amin commission. Listen. The Amin commission will go and submit a report. Then you will examine the Amin commission on oath in the witness box. They will do it. Thereafter, the court will pass an order.
Lordship.
Before that, you are not going to get any relief. But
Lordship.
you still want the matter to be in the High Court because it satisfies your
No,
personal whatever.
Lordship, because Lordship, just one submission. If Lordship grant me a liberty to approach the Lordship civil court, Lordship, I will do that thing. But otherwise, Lordship, what has happened? Because the Municipal Act says that there are 2 ways by which they can take Miadi Patta land. One is through acquisition process.
Mr. Das, they are saying they have not taken the land.
Lordship, they are not
First
saying.
question is whether they have taken your land. or
Yes,
not.
Lordship, they have.
How will you show it from this notification?
Lordship, let them file an affidavit and
Oh,
showing that.
they will not file.
Lordship, they are even not allowing me.
But
to
I will direct them to file affidavit.
Lordship,
But you give an undertaking that if you fail in the writ petition, you are not going to go to the civil court.
No, Lordship, if Lordship grant me a liberty, because straightforward, if I go to the civil court, no.
Because
Civil
this is
court-
what is happening. Every time, every land matter, land dispute, people are filing writ petition. They take a chance in the writ court.
No.
Some courts sometimes may pass an order, do this, do that. And then there are factual disputes. The civil court cannot go forward. The writ court cannot give a verdict. It creates a huge stalemate in these matters where parties get stuck up. You have to file review petition, recall of orders. Some party will oppose it. So all these things are happening just because some casual orders are passed by the court.
Yes, Lordship.
This court will not pass casual.
Lordship, if Lordship means dispose of the writ petition by directing that the petitioner can approach the civil remedy, Lordship, that will solve my problem.
All right.
Because otherwise, I am very much
Let them
inclined
do
to
it.
go to the, because I want compensation. They have, you are not spoil my entire land. Lordship, kindly have a look at the photograph, Lordship. My one part of the
No,
house.
nobody is denying you relief.
Yes,
All I'm saying is that in a writ petition, you cannot enforce anything.
Lordship, then Lordship dispose
right.
of this.
Then why don't you withdraw with liberty?
Lordship, if Lordship give a direction, it will help me, Lordship. With a liberty to
Heard
approach.
Mr. Das Learned Counsel appearing, G. Das Learned Counsel appearing for the writ petitioners. Also heard Miss
R.
R.
Dekha.
Devi, R. Dekha Learned Counsel appearing for respond
Respond
number
number 3 and 4.
3 and 4. Miss N. Bordelais Learned SC Revenue for respond number 1 and 2. And who is for 2? Mr. S. Boro for respond number 2 and Mr. Chetri
I'm for respond number 7.
and Mr. Chetri for 256. Be prepared when you are appearing in a court, in this court, be prepared to tell which respondent you are appearing for. After the court asks, then you will open your file, then we'll go through the thing. This is not going to work out. I've been telling it again and again. The moment your matter is called, you must know who's the respondent you are representing. So and so, write it serially. By filing this writ petition, a challenge has been made to the notification dated 29/7/2022, issued by the chairman of the Jorhat Municipal Board. Chairperson of the Jorhat Municipal Board. Inter alia contending that by the impugned notification, the private patta land of the petitioners has been illegally taken over by the board without following the due process of law. However, from a careful reading of the impugned notification dated 29/7/2022, I do not find any mention as regards the private patta land of the petitioners. First of Mr. Das has vociferously argued that although there is no mention of the petitioner's land in the notification, yet the reality is that the land of the possession of the petitioners over their land has been disturbed, as a result of which they are entitled to compensation from the board. First of, after hearing the submission of the petitioners' counsel, this court is of the opinion that the relief prayed for by the petitioners can be established only on adducing sufficient evidence, which can be done only in a civil proceeding. First up, in a civil suit brought before the competent court of jurisdiction. At this stage, Mr. Das seeks leave of this court to withdraw the writ petition with liberty to file a title suit before the competent court. The learned counsel for the respondents do not have any objection if the prayer is allowed. In view of the above, this writ petition stands disposed of by granting liberty to the petitioners to approach, to agitate their grievance before the civil court by filing appropriate suit.
Deeply obliged, Lordship.
By filing appropriate proceeding.
May please, your lordship, this writ petition is by filing for releasing of seized vehicles
and opening of a bank account, my lordship. Bank account, a petitioner was arrested in an NDPS case. During the course of investigation, the intelligence officer, he was arrested, but later he was released on bail, my lordship.
Yes.
Lordship, I am appearing for NCB on behalf of Mr. S.C. Keala, Lordship. Lordship, I have the instruction that the Home Ministry has taken up the matter, your Lordship. We have sought for them for instruction, your Lordship.
Home Ministry, we are not concerned. Question is, if he has been acquitted, then why are you
Yes,
keeping
sir.
his bank account under?
Lordship, I had still last
No, no, no,
Friday.
we
your
direct that
Lordship.
it should be defreezed. You can't do it. He has been acquitted.
Yes, yes,
It was freezed in connection with the NDPS case number so and so.
yes.
He has been acquitted. Has any appeal been preferred?
Yes, your Lordship. As per my instruction, one appeal has been filed.
Give me the
your
number
Lordship.
of the appeal.
Yes, your Lordship. I will provide you better number, your Lordship.
So you should have had it by now.
Yes. I will take instruction, your Lordship.
Heard Miss Begum Learned
Begum.
Counsel, R Begum Learned Counsel for the petitioner, also heard Miss S Dekha Learned Counsel appearing on behalf of respondent numbers 2 and 3.
2 and 3.
Who submits that an appeal has been preferred by the state against the order of acquittal of the writ petitioner, and therefore she be granted a week's time to furnish the details of the appeal. Mr. M. Datta, Learned Counsel, is present on behalf of the respondent number 4 bank. In view of the request made by Ms. Dekha, this matter be listed again after a week as a fixed item, so as to enable her to produce the details of the appeal preferred by the state against the judgment and order of acquittal of the writ petitioner.
Obliged.
A small issue is involved in this case, your lordship. Your lordship, the petitioner, your lordship, if your lordship comes to page 15, your lordship, your lordship, his dumper was hired by the GMC, your lordship, at a particular rate, your lordship, per day basis, your lordship. Now, page 15, your lordship.
Why aren't you paying his bills?
Now they filed an affidavit, your lordship. By filing the affidavit, they say now that some other contractors are doing work at a rate of 6,000 per day. That's why, your lordship, they want me to pay at that rate, your lordship. However, if your lordship comes to page 15 of my petition, your lordship, there is a specific, your lordship, work order issued by them saying that the rate will be 11,400. And on the basis of that, your lordship, I offered my dumper, your lordship. Had they told me at a relevant point of time that it will be at 6,000, I would not have offered, your lordship. After
What had happened, my lord? What we'll see, the dumper is, the other person is giving a dumper of 12 cm, bigger dumper with lesser amount, but he's giving a small dumper with much higher amount, my lord.
No, but the work order is whatever.
Work order, but that I have seen, my lord, the work order was different, my lord.
You have to pay.
But now, because of the ultimately pay, that public money will be siphoned out, my lord.
Find out who is responsible.
My lord, already,
Is the
my lord,
public
large
officer
numbers of
responsible?
engineers have been suspended for this kind of activity.
You can't do it. You have issued him a work order.
Lord,
by
I have,
the-
that work order has been issued, my lord.
If he is asking anything beyond the work
No,
order, then you can't.
That is not, my lord.
But
The
otherwise,
amount is, the vehicle is also small, amount is also high, my lord.
why have you accepted it then?
At that point, later on, we have discovered, my lord, persons are giving bigger than dumper with less amount.
No, it happens, but then this time it is
Lordship.
gone.
Lots.
What is the
I-
amount?
The dumper is, which is, other person is running is 6,000 rupees.
No, how much will he get?
He's 11,400 rupees charge. For a
Per day, how many days he is given?
Isn't that file calling?
it was, your lordship, I have, it was in page 7, your lordship, of my writ petition.
There was some expression of interest.
Lordship.
No, your lordship, nothing of that kind, your lordship. They have, your lordship, allowed, your lordship, 4 or 5 persons, your lordship, to. And this, your lordship, is on the basis of a earlier tender, your lordship,
where rate has been fixed, your lordship.
So no tender was,
No, no tender was this in this case, particular case, your lordship. Only your lordship.
then how did you come to know
Which about this, your lordship?
about that they were?
No, your lordship, we are all MPanel contractors of the GMC, your lordship. Now, we have these dumpers in your lordship and they offered us, we accepted that, your lordship. And they have executed, and there are other things also, your lordship. I don't know about that, your lordship, about the other person, your lordship, 6,000. Our, your lordship, dumper was used 3 times, 4 times a particular day, your lordship. It may be a case that is not been, your lordship.
All right, I had Mr. S. Bothakul and counsel for the petitioner also had Mr. S. Boral and standing counsel GMC appearing for the official respondents. The facts of the case in a nutshell are as follows. The writ petitioner claims to be a government class 1 bracket A bracket close contractor registered under the APWD bracket R and B. What is APWD? Assam Public
Works Department.
bracket R and B bracket close, and is also an independent contractor under the GMC authorities, full stop. In terms of the work order dated 26/9/2022, bracket annexure capital B bracket close of the writ petition, the petitioner had let out his dumper of capacity of 8.5 at the rate of rupees 11,000, had let out 3 numbers of dumpers of 8.5 capacity at the rate of rupees 11,400 per day for a period from
26/8/2022.
26/8/2022 to
Till your lordship on
26/9/2023.
6/3/2023.
Huh?
Till 6/3/2023.
Till 6/3/2020.
Vehicle has hired lordship has hired for 15/9/22. Down below 15/9/22. Schedule number 4, terms of condition, in page number 16.
For the period mentioned in the work order, full stop. After execution of the work, the petitioner had submitted bills against hiring of dumper by the respondents. However, the bills of the petitioner have not been cleared till today. Aggrieved thereby, the instant writ petition has been filed. During the pendency of the writ petition, the respond numbers 1 to 5 have filed counter affidavit inter alia contending that dumpers of higher capacity were available on hire at the rate of rupees 6,000 per day, and therefore the rate claimed by the petitioner was exorbitant. Full stop. Mr. Bora submits that since public money is involved in payment of the bills of the petitioner, the respondents have a duty to verify the claim and figure out as to whether the petitioner is charging exorbitantly. Full stop. Mr. Bothakul, on the other hand, submits that the respondents have issued the work order clearly laying down the terms and conditions, including the rates payable for each of the dumper. And after the work is executed, they cannot now turn around and take a different stand in the matter to the prejudice of the petitioner's interest. Full stop. After going through the materials available on record, I find that a work order was issued to the petitioner clearly laying down the capacity of the dumper, the period of usage, and the rate that would be applicable in case of each of the dumpers. Full stop. On receipt of the work order, the petitioner had executed the work and thereafter submitted bills. At this stage, the petitioners have taken a stand that the rate is exorbitant. Full stop. Once the respondents have agreed to pay a particular rate to the petitioner for using his dumpers, and the same is reflected in the work order in specific terms, such conditions would be equally binding on the contractor as well as the respondents. Therefore, the respondents cannot now resile from their stand merely by stating that dumpers were available at a cheaper rate in the market around that time. Full stop. In view of the above, I am unable to accept the stand of the respondents. As such, this writ petition is hereby disposed of by providing that the bills of the petitioner as submitted, the bills of the petitioner be processed strictly in accordance with the terms and conditions contained in the work order dated so and so, and the amount be released as expeditiously as possible, preferably within a period of 45 days from the date of receipt of a certified copy of this order. Writ petition stands allowed.
Deeply. This is by non-payment of higher assessors bill of vehicles, my lord. The respondent has filed a affidavit, my lord. They have admitted my bills. Now they say that they could not make the payment due to, my lord, they have not received the sanction from the sanctioning authority.
Who is for respondent number 3?
I'm appearing for all the respondent here. So already the bill has been checked and it has been forwarded to the sanctioning authority. And once the sanctioning authority come up with the sanction order, they will be getting it, but I don't know how long it will take.
Who
So
is the
matter.
sanctioning authority?
That was
Respondent 3.
the page 130, my lord, paragraph 4, my lord, of the affidavit.
Not sanction.
Bolero vehicle. What
Yes, my lord. But there are other vehicles also, my lord. Bolero, my lord, Scorpio, Maruti van, and Maruti Eco, man. Paragraph 2, my lord. Respond number 3.
Who is the sanctioning authority?
It might be from the DGP office, my lord.
Office of the Director General of Police.
So what is the time frame? You tell us, that's the order we can pass.
Or else let it be within 2 months. Within 2 months, because there are a lot of bills. In fact, they have to pay.
I had heard Mr. S. Botagula, counsel appearing for the petitioner, also heard Mr. S. Botagula, G. Assam appearing for the respondents. The respondent number 3 had taken 7 numbers of vehicle belonging to the petitioner on hire at a rate previously fixed for each vehicle. First up, the petitioner had accordingly submitted bills as rent of hiring the vehicles before the respondent number 3. The total amount of which was rupees 48,32,247. However, when the amount was not released, despite repeated representations made by the petitioner, he has approached this court by filing the instant writ petition. She has approached this court by filing the instant writ petition. The respondent number 3 has filed counter affidavit, virtually admitting the claim of the petitioner. However, as per statements made in paragraph 5 of the counter affidavit, it appears that the proposal for release of fund and sanction of payment had been forwarded to the competent authority. Full stop. It has been stated in the counter affidavit filed by the respondent number 3 that once the funds are made available, necessary steps would be taken for payment of the outstanding dues of the petitioner. The learned government advocate Assam is, however, completely non-committal as to the time frame that would be required for making arrangements for the funds and oblique or the sanction for payment of the bills. Situated thus, and in view of the pleaded stand of the parties, this writ petition is hereby disposed of by providing that the respondent numbers 1, 2, and 3 shall do the needful to ensure that the outstanding dues of the petitioner upon proper verification is released as expeditiously as possible, but not later than 3 months from the date of receipt of a certified copy of this order. It stands closed.
Maybe in this matter, request sometime the affidavit reply has not come on record.
You want some time? How much time?
No, we have.
Affidavit in reply has not come. with
Not
the
come
record.
on. We filed it way back, 22nd. 29.
Yes, Lord. Okay, good.
Interim order to be.
What, this has to be heard and decided.
Can be heard and decided. 2 weeks time.
List after 2 weeks, no? Not Mr. M.Z. Ahmed, learned senior counsel listed by M. Dr. Learned counsel appearing for the writ petitioners. Also heard Ms. M. Dev, learned counsel representing the respondent. Mr. Ahmed submits that the rejoinder affidavit filed by the petitioner on 22/9/2023 is not tagged with the record of this case. As such,
29/9.
this matter be posted.
29/9.
29/9/2000. As such, this matter be posted along with the rejoinder affidavit. The same day, learned counsel for the petitioner is present and seeks posting of this matter after 2 weeks. After
And
2
it
weeks?
may be fixed, Lord.
All right. In view of the request made at the bar, registry is directed to list this case again on 8th of November 2023 by taking the affidavit with the record of this case. 8th of November.
Meantime, the interim order may.
Interim order passed earlier to continue till then.
May it please your lordship, my lord, the petitioner is a cooperative society which license has been cancelled for delaying delivery of the goods. My lord, if your lordship turns to page in the writ petition page,
So affidavit has been filed.
my lord, affidavit and rejoinder filed.
All right, readings are complete. So we'll fix a date. Today is not possible. And it is not possible before vacation.
I understand.
Yes.
Because my lord, for no fault of my criminal case got final report. My lord,
7th November. 7th November. Heard Mr. P.K. Racholi, learned counsel appearing for the petitioner. Also heard Ms. H. Borua, learned G. Assam appearing for the official respondents. It is submitted at the bar that pleadings have been exchanged and this matter will be taken up for final disposal at the stage of admission hearing. In view of the above, registry will list this case again on 7/11/2023 as a fixed item.
Item 46.
May I be the lordship?
Yes.
Lordship, the petitioner is the president of Botodaba Gaon Panchayat. She received complaint, public complaint, that in the allotment of PMI houses, there are so many anomalies there. Accordingly, she opposed before the BDO and deputy commissioner. The deputy commissioner, lordship, on 26/4/2023, directed the circle officer to conduct an inquiry and submit a report on 10 days. But no inquiry has been conducted as directed by the deputy commissioner. After that, the petitioner.
Yes, have you received instruction?
Extra copy not received.
Lordship, I have already taken steps on 14/2023. Always half copy, lordship.
All right, then hearing on extra copy after vacation. What to do? She is saying she has not got, you have said you have given. First, the court will have to decide whether extra copy has been furnished.
I will have extra.
All right, Mr. Angel Gogoi, learned counsel for the petitioner. Also had Ms. S. Borua, learned GA Assam, and Ms. N. Bora, learned SCPNRD Assam, appearing for the official respondent who submit that extra copy of the writ petition have not yet been furnished to them, as a result of which instructions could not be obtained. Since Mr. Gogoi has undertaken to furnish extra copies to the learned standing council within 3 days from today, register to list the matter immediately after the reopening of puja vacation. In the meantime, respondents to obtain instruction and file affidavit.
Please, your lordship. Short issue in this matter. But the petitioners before your lordships had purchased these 3 plots of lands sometime in 2007 and in 2008, my lord. We applied for mutation and the process was not even initiated. It was rejected at that point of time in 2011, 2nd November.
2 and 3, 2, 4, 2 to 4.
2, 3 and 4, lordship. Here also extra copy not received. Our letter.
31st August, I served, my lord. The system, yes. 31st August, the system is also reflecting that.
Then
Yes.
hearing on extra copies.
I found out.
Instruction,
Your lordship's hands.
I have to take instruction.
Instructions. No, you sort it out. Don't look at the
I will,
court.
I will, I
We
will.
can't
my
get
lord.
into extra copy dispute
No,
here.
I will.
Whatever you do, you sort. If you want some time, we'll have it after
The
vacation.
issue is actually very short, my lord, because it only confines to if I am inside the retainable area, my lord, then I'm out, my lord. The writ petition can't stand.
No, that's correct, but should we decide it without giving
No,
them?
of course not, my lord. I'm not saying that,
Then
but there's a
if we have to
limited
give
point in
them-
which they really need instruction, my lord. I'll serve them, my lord.
3
You
weeks.
obtain instruction is a
Yes,
short issue. Immediately after reopening.
My lord.
All right.
Could it
All right,
be,
Mr. Pukan, I'll not record anything else, only prayer for obtaining
my
instruction.
lord, my lord.
Yes, you are saying something?
Could it be 8th or 9th subject to convenience of November?
8. Apukon Land Council for the Rectification also had Ms. S. Burwal and G. Assam appearing for the respond numbers 2 to 4, who submits that further 3 weeks time is required to obtain instruction. In view of the prayer made by Ms. Borua, registry to list this case again on 8th of November 2023.
Deeply obliged.
So to enable her to obtain instruction.
For orders, item 48.
My lord.
Your lordship, I may pray for some more time and with leave to file one additional affidavit. Because the reply that has been filed, thereby it has been found that there was some miscommunications in regarding to the affidavit that has been filed at the debt recovery tribunal recovery offices.
My lords, if I may, my lords. My lords, I'm on application file under 466 of the old Companies Act, my lords, seeking stay of the winding up proceedings. On the premise that a satisfaction application by me has been preferred before the TRT RO's office, my lords. The notices have been issued. In fact, after the last date of hearing before your lordships, matters has been listed twice where they have been issued repeated notices. The application has been pending for the last 2 years, my lords. They still haven't filed the reply. The RO has also made these observations. I can show you the last orders was passed on the 25th of September, my lords. I did not get an opportunity to file it before your lordships. If I can pass that orders today also. The issue is this, that my case before the learned DRT is that the entire debt now stands satisfied, my lords. An order adjudicating that fact has to be pronounced now by the RO. Pending that, my lords, I'm just seeking stay of the current winding up proceedings. That's about it, my lords. If I'm successful in that endeavor, my lords, this entire matter becomes infructuous. In any case, my lords, they have now, before the learned DRT, my lords, on the strength of an affidavit, they have admitted that 3.16 crores worth of
assets are lying in the hands of the OL yet to be disposed of. My lords, then, I mean, the entire, and I'm not even the principal borrower, my lords, I'm a co-guarantor.
We are not the sole beneficiary of the entire amount.
Be as it may, my lords, we are here
That is
before a
not
winding
been
up court.
admitted Because OL has not filed their report.
All right, heard Mr. K. Khanna, learned counsel appearing for the applicant. Also heard Mr. M. Sharma, learned counsel appearing for the OP. Stroke company
SDFC.
petitioner who prays for further 3 weeks' time to file an additional affidavit in the matter. This IA has been filed in by the applicant with a prayer to stay the third winding up proceeding initiated against the applicant company, inter alia contending that the debt due and payable to the OP bank has already been discharged.
Is yet to be crystallized, and my lords, my case is that the entire debt is satisfied, as per me, my lords.
Is yet to be crystallized. However, as per the materials on record, the entire debt of the opposite party bank has already been satisfied. Mr. Khanna submits that an application has been moved before the
Learned recovery officer, DRT2, my lords,
recovery
Calcutta.
officer, DRT, Kolkata. And if his client succeeds in the aforesaid effort, then the third winding up proceeding will be redundant. First up, the learned counsel for the OP has not been able to take any concrete stand in the matter. First up, having regard to the facts and circumstances of the case, I am inclined to grant 4 weeks further time to the OP to file an additional affidavit. However, in the meantime, it is provided that further proceeding in respect of the third winding up proceeding shall remain suspended until further orders.
Grateful, my lords.
May I please, Lordship? Lordship, on the last occasion, Lordship, this honorable court directed to us, Lordship, to obtain instruction whether ARDC is willing to accept the notice on behalf of respondent number 2 or not. Lordship, where is the instruction, Lordship?
On 5th of August 2023, my lord, your lordship was pleased to obtain instruction.
Yes, what is the instruction? What is it? Tell me, I can't read all this.
Lordship, with reference to the that the petitioner who are contractors are aggrieved by non-payment of their contractual dues by the erstwhile in the Hindustan Paper Corporation, it is stated that Honorable NCLT Delhi bench passed liquidation order on 02/05/2019 for liquidation.
Heard Mr. H. Bora and counsel appearing for the petitioner. Also heard Mr.
DJ Bora, Lordship.
DJ Bora
Yes,
as counsel appearing for the respondent number
5.
5.
And respondent for Industry and Commerce Department.
And Mr.
N. Kalita.
And Kalita appearing for respondent number 4. Give it in serial order. Mr. Bora has obtained instruction and has appraised this court that his client cannot accept notice on behalf of the respondent number 2. If that be so, the petitioner is directed to take fresh steps for
My lord, we can take steps, but there's no, my lord, harm on that, my lord, but difficulty is that the office where we have taken steps on the last occasion in the Lawazima order, it has been reflected that they put the office on lock and seal cover, my lord. So
then substituted method you do it, we have to proceed.
yes, my lord, of course, that is a difficulty, and they being one of the custodians now of the same property that they have undertaken, so they should be in a position to take notice, my lord. That was
We'll have to hear on that point.
yes, my lord. So, my lord,
So
anyway,
first we'll hear on whether you need to take steps or not.
yes, of course, I'll take steps, my lord. On a substituted method, my lord, we can carry on with by taking the step, my lord.
In view of the above and on the request of Mr. Borgohain, leave is granted to the petitioner to take steps for service upon respondent number 2 by substituted method, that is through newspaper publication. Notice of this case be published in one English daily newspaper and one vernacular newspaper having wide circulation within the state of Assam, showing the date of appearance in this case as 20th of November 2023. let the matter be listed again on 2011-2020.
I'm deeply
Deeply
affected.
affected.
Deeply affected.
May it please your lordship, as per the last order, your lordship, they have to file the affidavit, your lordship. By 11/9.
Can be granted matter to file the affidavit for.
If your lordship will see the
Therefore,
order, then
For the petitioner, on the request of Mr. Jute, a further 2 weeks' time is granted to the respondent to file affidavit. It is made clear that no further time will be granted for filing affidavit to the respondent in this.
may I pray for a fixed date, your lordship?
Yes, it will come up on 10th of November.
Obliged, lordship.
List
Sir,
again on
Not 10th, my lords, not 10th, any date, my lord, other than 10, my lord,
14th.
14, my lord.
Obliged.
They may shake notice 8 weeks, sir. Single item, single petition.
Which is the lordship.
My lord, in this matter, my lord, I'm appearing for private respondent number 6 and 7, my lord. I pray for 3 weeks time for filing affidavit.
This is so learned counsel is appeared. for
Yes,
the
that's-
petitioner. Mr. S. Thus learned counsel appearing for private respondent number
6 and 7, my lord.
6 and 7, prays for 3 weeks further time to obtain instruction and file affidavit. Mr. N. Goswami, learned G. Assam and Ms. N. Bordole, learned SC Revenue Department Assam are present on behalf of the official respondent. On the request of learned counsel for the private respondent, this matter stands adjourned for 4 weeks. Interim order passed earlier to continue.
Highly obliged.
For hearing, item 56 and 57.
May it please your lordship. My lord, counsel, Mr. B. Gogoi is on legs in court number 12, my lord. However, my lord, according to last court's order, my lord, we have received only 1 matter's report, my lord. There is something supplementary 56, my lord. Matter may come on Monday, my lord.
Monday, the hearing is not possible in these matters.
Any other
Had
day, my
Mr. Had learned counsel for the petitioner, also had Mr.
H. Burwa.
H. Borwell, learned counsel appearing for the respondent who seeks posting of this matter on 12/10/2023 so as to enable the department counsel to proceed, produce the entire records